IPR, Intellectual Property Rights and Commercialization, Strategies for Protecting and Monetizing Innovations. So as you are all aware that IPR is playing a very critical role in fostering innovation and enhancing the competitiveness for MSMEs. So for innovators, startups, researchers, and also MSMEs, it is a need of the hour to know about how to protect their creations and effectively commercialize them, as it is very much essential for sustainability. And this particular online webinar is going to create awareness and to build the practical understanding on IPR aspects, and also it helps in understanding the commercialization pathways and how to manage the IP, and also the role of government, especially the policy interventions that has been taken place in order to promote innovation and IPR, so that the MSMEs and the startups and the researchers that can be that will be helpful for them to exploit this IP, and also uh, commercialize them, and to get the monetary benefits. And this particular webinar helps you to safeguard your innovations, and it will also highlight the types of various IPRs and its registration process. And we also have the eminent speakers who are having the excellent knowledge and having the practical exposure, okay, in dealing with this particular aspect. So we have the speakers from CSIR, IACT, and we have an empaneled IP attorneys, and also we have an expert from National Research Development Corporation, from the SIR. So we will be taking the sessions. And coming to the first session, we have an overview of IPR and innovation ecosystem. So this I will be taking it, and coming to the overview of IPR. So IPR means it's a legal right. It is granted to an individual or any entrepreneur or any researcher who has done some innovative things that comes out of the intellectual, so which has some commercial value. For instance, it can be a product, it can be a process, it can be a software, it can be any name, any brand, or any know-how which has some commercial value that can be protected through intellectual property rights. And intellectual property rights is very much needed at present scenario, because you have to differentiate yourself from others, and you have to sustain in the market. So the people put efforts to bring out some innovations and to be unique in the markets, and for that intellectual property rights plays a very important role. And we have various categories under intellectual property rights. We have patents, trademarks, industrial designs, plant varieties, copyrights, geographical indications, and we also have a layer of design of integrated circuits and confidential information that is protected as trade secrets. So these are various categories under IPR. We'll have an in detail sessions, but in a broader way I will just brief about what the patents are. It mainly protects the products or the process which has some novelty, and whatever the new technologies, especially the new machines, devices, process, and the compositions, especially in the pharma sector. There are a lot of new drugs coming out to treat certain diseases, so all that can be protected under patents. And we also have trademarks, which will protect the brand names, symbols of a company or the brand of the company, which helps him to distinguish their product or services from others. And we also have the copyrights, which mainly protects the literary works. And we also have design, which will protect the unique designs, okay, that is applied to an article. It can be any design which is being developed, and it is applied to a product, that can be protected under design rights, design registrations. And we also have a geographical indications, mainly protects the um, products which has been originated in a specific region and has certain unique qualities linked with the geographical location. And we also have a trade secret. Many business, they have certain information which is very crucial for their business, so those things can be kept as a trade secrets. So these are various categories, and these are very much need for protecting your innovations. And we in India, we have a very good innovation ecosystems, because these ecosystem mainly have the institutions, people, and the government, which makes a policy that work together to foster the innovation and entrepreneurship. And government is mainly focusing on entrepreneurship to create the employment. And for enterprises to sustain this, innovations plays a very important role, and IP is very much important to protect the innovations. So the key components in the innovation system is academia and research institutions, which mainly generate the new technologies and the new research that is going on. And we also have in industry startups and universities, financial institutions which fund for the innovation. And we also have the IP professionals and the legal frameworks which helps the IP protection and the commercialization. So IP plays a very crucial role in promoting and sustaining innovation. So IP as a legal right protects the innovations, and it encourages R&D investment, and also uh, helps them to transfer the technology. So, as I mentioned, there are various categories of IP, especially the patents, which are protecting the new products that is coming into the market. And any entrepreneur or the startup who has developed a new product before entering into the market, if they protect under the patents, and they can be unique in the market, and if any other company want to sell that particular product or manufacture it, they have to do it with the permission of the owner. So that's how the patents helps them. So it also generates a revenue by way of technology transfer, and making the partnership with some institutions who can collaborate jointly and develop that product. And it also helps in creating the market advantage, because these companies who are having the IP, they can differentiate themselves, because they have the patented technology and they can only sell the product in the market. Okay, so that's how they have the market advantage. And by leveraging the IP, by especially by giving the license or technology transfer, they can generate, or they can sell their product in with a premium price, and that will help in turn help in economic growth of the country. Okay, so this, we in India, we have a very good ecosystem, especially after 2006. We have a national IP policy, which has set certain objectives, especially spreading the awareness, and also creating an ecosystem for filing the IP, and also for managing, and also for generating the revenue out of the IP. There are a lot of support system that has been developed by the government, and this IP policy has been created a strong institutional and policy foundation, which helped in spreading the awareness about IP and commercialization. And also this was helpful in technology transfer. And even there are a lot of schemes that has been initiated by the government, where any startup or an MSME can access the new technologies that are coming out. And with And there are also support system by way of reimbursement, and also like facilitation center, like intellectual property facilitation center, where they can get the support of IP services with free of cost. Okay. And coming to this innovation, and how this innovations coming to picture, mainly many research institutions focus on new technologies and developed certain solutions for the problems that is existing in the industry, and these innovations are protected through IP. And that's how we see many research institutions like CSR, universities, academic institutions are focusing now on IP generation, and also exploiting them, and helping startups to come out to bring their technologies. And with the government support, many industries or many enterprises who are having certain innovations, they have the support system which by which they can scale up these new technologies which are protected by the IP. And there are also incremental innovations that is happening when an enterprise is bring their IP product, protected product. There are new features or any incremental developments that is happening, so that are also protected by the IP. And that's how the company can able to get the monopoly in the market, and they can generate revenue, not only in the domestic market but also in the international market. So, as I said, pre 2006, there was a lengthy procedure in examining the IP registration process, and we also have a very low investment in the R&D, and there was no much research happening, and it is only limited to the patent. But now the government and even everyone is insisting how to generate the revenue from the patents or the IP that is being generated. Okay, that's how many academic institutions and the research institutions is focusing on bringing the technologies to the market, and there are a lot of schemes that is supporting to bring that ideas or the technologies, and MSMEs can access those technologies and bring that to the market. And
Madam, you'll be
we also
sharing these
had
slides, right?
Hmm?
You'll be sharing these slides.
Yes.
Okay, because there is some portion of this panel or something of speakers that is covering the presentation. I do not know how to remove it.
Ma'am, I think, yeah, it is from your side. Yes, now it is removed.
Yeah,
Okay.
because past few slides it was half covered.
Okay. So there was also lot of concerns relating to counterfeiting and piracy across the sectors, and there is also no strong IP policy in place. Okay, so that with these issues, the government has thought about introducing the national IP policy, and which has vision of creating India and innovative India. And there are seven pillars which this IP policy was focusing on, mainly on awareness, creation of IP, protection, administration, commercialization, enforcement, and human capital. So, coming to the first, awareness, there is a lot of awareness programs that is being conducted throughout India through various schemes, and there is a even capacity building of the police officers, enforcement agencies, and there is also even the customs officials were given the inputs on given the awareness about the importance of IP and how it can be created and how it can be protected, and what are the remedies that is available. All that information were given through the programs. And there is also a strong administration that has been developed in intellectual property office, because earlier there was no IT tools, no enough information that is given to the public. Now they have introduced AI tools where any startup or any individual can go through their application status online, which is publicly available. And even the procedures, okay, it was very time taking, but now they have amended all the rules, and they have made it very easy for anybody to know the procedure, and also and to get to know the status of the application that is filed. And there is more insisting on the commercialization aspects. That's how there are new schemes that has been developed. At the end we will have the what are the different schemes that is supporting the commercialization process. And also we have enforcement cells which was being set up in the high courts, and that is how now the IP issues are also taken up. And there is a shift from the protection only to the innovate led growth, because earlier there was more focus on spreading the awareness and also for protecting the IP, but now there is focus has been shifted now to generate the revenue out of the IP protected the product or the services. Okay. And there is a body agency which has been established under Department of Industry and Commerce, Ministry of Industry and Commerce, for the smooth coordination and the outreach activities that is being taken as a part of the national IPR policy. Okay. And there is a balanced approach, because only the IP protection will not help for the growth of the country. It is also the public interest has been taken into consideration, and the rules and regulations have been framed in such a way that both the public interest is also kept in view, along with the protection of the innovations. So these are the various aspects that is considered in the national IPR policy. And then recently a lot of amendments has been taken place in the IP rules, where a fast track examination has been introduced for the startup applications. And also there is a strict timelines which has been fixed in the process, so that anyone who has filed an application, they can get to know by what time their applications will be processed. And even for the officials who are actually examining that application, will have the timeline set, okay, within which they have to dispose that particular application. So that's how the IP protection rules and regulations have been amended. And after the IP has been generated, how to generate the income out of it. So there is a lot of focus on that. Government is giving a lot of support for MSMEs and startups to bring out their new technologies into the market. Okay, so these the focus of the national IPR policy. And we have the in detail sessions on each one, and I will be also taking the session on the government grants on various aspects, especially in protecting the innovative ideas, and also in registering the IP, and also the commercialization institutions that will support the commercialization aspects. Okay, so these are the certain aspects that are covered in the national IPR policy. uh, and we have the current trends presently. After introducing the national IPO policy, we could see in the last 5 years around 44% overall increase in the IP filing, especially in the patents and the trademarks. There is a drastic jump in the filings of the IP. And we could see the highest growth in geographical indications, and especially the micro enterprises. We see in the facilitation center there are a lot of micro enterprises that are coming forward to file the design registrations and trademarks. especially because that is a simple innovations that MSMEs can make and protect their innovative ideas or the innovative designs that they have generated. Okay, so these are all the certain aspects where you can see a drastic change in the MSME perspective. And coming to the startup driven innovation, we can see there are a lot of startups coming out, and this is because of the ecosystem that the government has facilitated. Because even in the academic institution, we can see that incubation centers have been established to help the students' ideas to develop that prototype or the product development. And even there's supporting many startups who are coming out with innovative ideas. And we could also see the schemes that has been introduced especially to support the startup who are having some innovative ideas. This is all the figures we can see in the recent news. We could see that there are 100 plus unicorns that have been come out, and in that we see mainly women led startups. We can see the increase in the number of startups that has been led by the women. And there is a startup intellectual property facilitation scheme where startups are availing the startup startup facilitation services, and they could get certain benefits like fast track examination, and there is also tax exemption that is being given for the startups who has the IP protected product or the services. So that's how we can see a lot of change, lot of benefits that is given to the startups. So these startups have been, especially in the deep tech sectors, we can see there a drastic growth in the IP backed IP, especially IP protected startup. Especially we can see a drastic growth in the deep tech technologies like AI. And we also see in electronics and communication area there are a lot of IP being generated. And especially we have a policy who especially the policy which helps the student ideas, or also the MSMEs or individuals who are having some innovative ideas. There is funding that is being given by the ministry, especially the MSME ministry. So we can see there are a lot of innovative ideas that has been developed by the individuals, especially solving some industry problems, and also giving the solutions. We can see recently in NIMSME we have support two innovative ideas. One is on multi-millet rice, where they have made a rice with combining the seven varieties of ingredients of millets, and it is a ready to eat rice. So this has been funded under one of the scheme, MSME scheme. And there is also one more innovative idea that is relating to fire safety chute, which is developed by one of the women innovator. And she has developed that particular fire safety chute with the support of this ministry fund. And this idea actually helps in high-rise apartments where they can establish this particular fire safety chute, and in case of a fire accident they can escape from that. And these two innovative ideas has been supported by the NIMSME. So like this, there is a shift from the idea generation to the revenue generated innovations that is been taking place. and with the support of the government. So that's how we can see a lot of startups which treat IP as also as a asset. Earlier IP was taken as a just a legal right, but now they have been using as a business strategy to differentiate themselves from others in the market, and also uh, it also helps them in generating the revenue out of it by licensing or by technology transfer. And that's how the startups getting the confident, even they are very helpful in attracting the funding. So angel investors or the what you say this funding financial institutions show very much interest in funding these startups which is having an IP protected products. So these are the certain aspects uh, which are which happened actually after the national IPR policy that has been introduced. And now there is a very good innovation ecosystem that is being developed for startups and MSMEs. So that how this IP has been helpful for them. And now there is a focus on the commercialization. So we have to have an system in place to help the MSMEs in exploiting their IP in generating the revenue. That's how we have the facilitation centers. So one of these is NIMSME, and that is the reason why we are giving this particular webinar to highlight what are the aspects that is covered under the IP commercialization, and also help them to support in linking and getting the network with the investors and or the companies who are willing to take this particular technologies. Okay, so this is a little bit overview on the innovation ecosystem, and we have an in detail sessions on each of the aspects by the other speakers. And at the end we will be also having the government funds that is helpful for promoting the IP and innovations. Okay, so if you have any questions we will take up at the end, but we will begin with the next session by the CSIR scientist, who will be taking on the different types of the IP and their registration process. Now I request Krishna Prasad Garu to take over and start the different types of IP and their registration process and its benefits. Um, so, Dr. Kancharla Prasad, he is a doctorate in chemistry from Hyderabad, and he is currently working as a principal scientist in CSR IICT. Hyderabad. He is also a registered patent agent, and he has a lot of experience in IP. And now he is responsible for overseeing the MSME Technology Transfer Center at IACT. And now I invite him to deliver the session.
Um, so thank you, Swapna Garu, for the kind introduction. So hope you could able to see my screen. So can you see my screen?
No, it is covered. Yeah, now it is okay.
So now it is visible now. Right. Yeah, we'll see different types of IP, how it can be protected, and the tenure of each kind of IP that we protect. So, CSIR annually conducts National and Intellectual Property Festival as a part of Azadi Ka Amrit Mahotsav lecture series. Prior to joining to IICT, I worked in CSIR IIIM Jammu as a senior scientist. There, I have trained almost 5,000 plus participants and created IP awareness education across Union Territory of Jammu, Kashmir, and Ladakh. I couldn't move my slides. Right, right. Right, this is the Azadi Ka Amrit Mahotsav lecture series flyer. Annually, CSIR do this. And coming to our presentation, can you go to these two images? One is intangible property, another is tangible property. What could be the major differences between tangible and intangible properties? Can any of the participant, can I guess any answer? Tangible and intangible. So tangible properties are movable properties, intangible properties are immovable properties. So IPR is a creation of human mind's intellect and it's an intangible property. Exchange rights given by the statutory authorities. The statutory authorities are Indian Patent Office with respect to patents, and the Controller General of Patent Design Trademarks is the highest authority for patents in India. Any type of IP. Any type of IP in India, exchange rights. We are exchanging our knowledge in the public domain free of cost. In return, the statutory authorities are giving us the exchange rights. Exchange right means the period of protection of your IP. For suppose patent, the period of protection is 20 years. For suppose the trademark 10 years and you have to keep on renewing it. So it's time bound and territorial right. Time bound is, I said, the period of protection over once the term of your IP is over. Territorial right. Territorial means if you file an IP in a particular jurisdiction in India, so that IP is valid in India only. Someone else, you can't stop or sue someone who is practicing in a foreign country when you file your application only in Indian jurisdiction. If you have market potential and could able to commercialize your invention in any abroad country of your choice, there also you have to protect your IP to stop potential infringers from copying your inventions. So IP is a idea, inventions, original work manifested in a tangible form that can be legally protected. So intellectual property rights are legal rights that give exclusive rights to the creators or inventors. It enables them to reap commercial benefits from their invention, commercial benefits from their creative outputs or invention. The purpose of IP is to protect against unauthorized imitation. So unauthorized copying of your own invention, protected inventions. If you protect your IP, you could stop potential infringers from copying your original ideas. So why IP matters? It helps showcase your technology inputs. If you are a startup or MSME, it could be a fund generating asset for you. Suppose a big player in your technology area is interested in licensing in your IP. So you could draft a licensing agreement, and based on that, the terms and conditions you could incorporate in the agreement if you commercialize the product. So there could be deals like upfront payment. You are acquiring my IP, so straight away IP acquisition fee you can demand based on the potential of your invention, 50 lakh, 1 crore, 2 crore. Then royalty clause you can keep in the agreement. For each batch of product that is being commercialized and entered into the market, you can ask 2%, 3% royalty on sales. So that way IP could help could help you as a fund generating asset, and it blocks your competitors from copying your invention and stops potential infringers. Product licensing revenue. So I said, if you license your IP in terms of IP acquisition fee, it helps you generate some revenue. It's a great source of recognition for the inventors. So IP always gives great source of recognition. Apart from you publish the same invention, before publishing, you patent your application. Then go for publishing the same work, whatever you have drafted in your application. That will definitely help you. If a researcher or if a company with only publication is freedom to operate thing, anyone could else use the work whatever you have quoted in the research publication without your prior permission. But if you file an IP, then until unless you grant them license, no one can else could able to reproduce the same work whatever you have protected and obtain the legal rights with respect to intellectual property. So different types of IP in India. One could be patent. Second is the trademark, copyright, plant breeders' right, and if you have created a new design, it could be protected with help of design rights, geographical indication, and trade secrets. So geographical indication, a society has to file. In my subsequent part of the presentation, I'll let you know. So in patent, what could be protected? In patent, invention is protected. The period of protection is up to 20 years, subject to annual renewal. So every year you have to pay annual renewal fee to keep your patent active. If you feel after 5 years or 6 years or 10 years, once your invention is protected, then there are much better advancements came with respect to the particular product that you have obtained your IP. Now your product became old, then there is no point in continuing by paying the renewal fee of your patent application. At that time, you have an option not to pay the renewal fee, then your patent application will be lapsed, and once it is lapsed, it is automatically free to use. Any other company or your competitor can use your invention once your patent application is not active and you have not paid the subsequent renewal fee to keep your application active. If it is active, then no one can else do it until unless you license them. If some advanced inventions with respect to the particular product, whatever you have filed a patent application has entered into the market, then at that point there is no use for you to spend extra money and to continue your active patent application. That time you may opt to not to pay the renewal fee and the application will be lapsed, since there are already advancements with respect to the same product has already entered into the market.
How much is the renewal fee?
So it depends actually. In India, 5 years, 10 years, 15 years, 20 years. Last 16 to 20, it is 40 years. 10 to 15, it is 20 years. Initial 5 years, it is only 8 years. After 6 to 10 years, it is up to 12,000. So per year you have to pay. At a time, you can opt to pay for 4-5 years, or individual years also you can take a decision. So 16 to 20 years, it is costly 40,000 per year, or 10 to 15 years around 24,000. So you may take a call whether to pay that amount, whether your patent could be active and it is helping you generate some revenue. It is not generating some revenue, then you have an option to drop it. So trademark. What could be protected? Brand identity, including words and logos. So forever you could protect, and you have to pay renewal fee each year after every 10 years. The use of your trademarks by others without your permission.
So Prasad garu, here is a question.
Yes.
In a fast changing technology world, how would you know that advanced products have come into the market on the same subject? Would you be notified, or how do you?
Yeah, sure. You have to do market research analysis. When you are working on a particular product, definitely you have to observe the market, what advancement have come. And there is a provision with respect to intellectual property of journals. Every week they publish the patent applications. So you could ask your IP team or hire an IP attorney to monitor the weekly patent alerts. So every patent office, not only in India, it's PCT, US, or every country, they'll publish weekly journals. So whatever 18 months period is over from the date of filing, the new applications will get published. So you can keep a track on your competitors. That's what all corporate world will work on. keep a track on your competitors on what inventions they are working. So this week your competitor has published an application. So what type of invention it is, what product it is, you can download it, retrieve, access it, and read it, so that you could know that some advancements are happening in that product area. Hope it is clear.
Yeah, that helps, Prasad Garu. That
Yeah,
helps.
yeah, right. So then is design, right? You could file a design. You could help to protect your design. Suppose a design of a water bottle, or a design of a Coke bottle, design of a design shape of a mobile phone or a tractor. Any type of engineering design you created could be protected with the help of design rights. Period of protection is up to 25 years. And what you can protect is your product being manufactured, sold, or imported. You can stop even potential importers also if you have a protection for the same design in India. And copyright, you can protect music, artistic work, film, literary work. Broadcasting right is different. Suppose we all have watched IPL on different platforms in 2 years ago. Now we are all watching it on Geo Hotstar. So the reason is the BCCI has changed the broadcasting rights to a different company. At the same time, live stream cannot be presented by any channel unless they have obtained the proper broadcasting rights from that particular agency. So in detail, I'll let you know in my subsequent part of the presentation. Trademark, these are the IPR laws, Indian context, when these laws have been framed initially and currently in existence. Trademark Act 99, Patent Act 1970, Copyright 1957, Design is 2000 Act, Geographical Indication Act is 99. There is one more act, Protection of Plant Varieties and Farmers' Right Act 2001. And if you are involved in manufacturing of any semiconductor integrated circuit layouts, that has to be protected under this act. So in India, patent office, you could able to see head office is at Kolkata, branch office Delhi, Chennai, Mumbai. So four patent offices are there. Design office is at Kolkata. Trademark registry again Mumbai, Delhi, Kolkata, Chennai, Ahmedabad. GI registry only one office is at Chennai. You see the jurisdictions. Anyone, suppose we are residing in Hyderabad, we want to file a patent application. Earlier days, nowadays everything is online. Earlier days we used to file offline patent applications. So that time it has helped much. So we are falling under the Chennai Patent Office jurisdiction, like AP, Telangana, Karnataka, Kerala, Tamil Nadu, and Union Territories of Pondicherry and Lakshadweep. So we have to operate with respect to Chennai Patent Office. Similarly, people falling in North India has to opt for Delhi Patent Office and Mumbai. One more is Kolkata, based on the territorial jurisdictions. So these are the patent system in India is governed by Patent Act 1970 as amended by Patent Act 2005, and the rules are subsequently amended in 25 also latestly. So patent prevents direct copying of your invention, prevents other from infringing your inventions. It makes competitors find other solutions. So once we have protected a particular process, there is no other way to your competitor, whether they have to come and approach you for a licensing, or they have to find some alternative solution from the patented invention. So license, I have already told you, and it helps you facilitate technology transfers, facilitates in locating inventors. Whoever is listed as an inventor in your patent application, you could locate them. Types of patent applications, one is ordinary application. Again, it is provisional spec and complete spec. Provisional specification, there is a provision in Indian Patent Act. Once your invention is not complete, so, but that invention has huge demand, you know that your competitors are also working on the same invention. Then Indian Patent Act has given a provision to file a provisional application. Then you will be given 1 year timeline from the date of filing the provisional application. Within 1 year timeline, you can change the draft, whatever you want. You can execute all the pending experiments and complete data and file a complete application within the 1 year timeline of due date. Then your priority date will be given from provisional application only. So that way you could able to protect your priority date and a provision to file the complete application 1 year later. So patent of addition is granted for improvement of modification of already existing patent. Some mere small addition you have done to the already existing patent, then you can apply for a patent of addition. So the original, your patent of addition also expires with the your main patent application. Then divisional application. In case of plurality of applications disclosed in the main application, suppose you are a life science company, you have discovered a product for the first time. So in the same application, you disclose product, process for manufacturing that particular product, a polymorph of that product, or a composition, formulation of that particular product. If you incorporate all inventions in all concepts in a single patent application, it is becoming plurality of inventions. So there is a concept called single inventive concept, and examiner will allow ask you to file divisional application, one invention in one application, suppose product in one application, process in one application, composition in one application, polymorph in another application. So you have to file divisional applications with respect to your main patent application. So convention application claiming priority date on the basis of filing in convention countries. Convention countries, there are suppose you are an inventor working in Brazil. So you have filed your application in Brazil. There also you will have 1 year timeline to take your application to any country of your choice via conventional route. Suppose from Brazil you are entering into India, you will have 1 year timeline. Still the priority date is from the date of protection your application in Brazil only. Then within 1 year time you could enter into India. If you fail to do so after 1 year, your own invention becomes your own prior art, then you could not stop others from copying your invention in a country you have not filed the application. Second, last is national phase application under PCT route. PCT route. Instead of individually filing your application in multiple countries, you have a provision to file a PCT application. PCT is maintained by WIPO, World Intellectual Property Office. You all should know one point, that PCT is not a granting authority. PCT, your application is published. It doesn't have any value. It reroutes your application via national phase entry to a country of your choice. The timeline of national phase entry is 30 months for few countries and 31 months for few other countries. So you have to request PCT WIPO office that please reroute my application to USA, Europe, Canada, Japan, wherever your product has some commercial interest. You ask them to reroute, then PCT reroutes your application via national phase entry to that particular countries. The advantage of filing a PCT application is, instead of approaching each and individual single countries and filing individual applications at a go, PCT has a relation with MOU with almost 150 plus contracting states across the globe. You can, with a single application, you have a provision to reroute your applications to 150 plus countries at a go. There also, since patent applications filing in abroad is a costly affair, carefully observe, and wherever you find your product has a market potential, there you could able to instruct PCT to enroute your applications by national phase route entry.
What is the process for conflict resolution, Prasad garu? Are
Conflict,
you going to conflict
yes,
resolution? Should there be
conflict,
a conflict?
yeah,
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 should there be a conflict with regard to the patented subject? Okay, and that conflict, if it arises from
yes.
multiple countries, who is going to resolve such
See,
conflicts,
every country,
and
yeah.
what is the status pending conflict? What is the status of that patent
Hmm.
pending resolution?
Yeah, understood. Every country has their own arbitration. Suppose, so I'll quote you one beautiful example. Our Indian India is a bowl for generic pharmaceutical industries. So companies like sitting in Hyderabad, Dr. Reddy's, Cipla, MSN, everyone targets generic patent applications. Already innovator like Novartis, GSK, Pfizer, they have filed innovator. They have discovered the molecule for the first time. They have a NCE status from the US FDA. So what happens? Our companies challenges the innovator patent applications by filing a para 3 route. So there the arbitration starts at US Court of Law. US Court of Law, then initially it goes to district court. District court is not satisfied, High Court, and the last is federal court. So every country has its own arbitration. The IP suit goes on in the court of law. That court of law and patent office doesn't have anything. If once the court decision is granted that this patent is invalid, then that will be communicated to the respective patent office. That patent will be made invalid. Then it is free to use for each and everyone. Sometimes what happens, the innovator and the generic players come into a settlement agreement with each other. You don't argue against us in the court of law, you withdraw. For that, in return, we'll allow you to launch your product 1 year in advance before the expiry of our product patent, 2 years, 5 years. They enter into a settlement agreement.
Thanks for the explanation, Prasad Garu. It helps.
Yeah, thank you. Right. So this is PCT route. First, file a local application. In India, you are filing an application. File a PCT application within 12-month timeline. At 16-month, international search report and written opinion will appear in your WIPO application number status. So there you could able to see that you have a search report. Examiners are equipped with different patent databases. PCT generates a good search report. There you could see that whether your invention has strong potential or novelty. In the search report, it is indicating strong novelty. Then you have an option to choose national phase entry. If your search report is not that strong at this stage, also you could able to drop your invention, since the foreign prosecutions are costly. If your invention and search report is so strong, then you can go for national phase entry with respect to the country of your choice, depending upon the demand of your product. So one thing you should know, discoveries are not patentable, only inventions are patentable. Something that is already existing in the nature, we have discovered it for the first time. So discoveries are not patentable. Something that is not existing and we have invented it for the first time, that is patentable. Beautiful example, someone discovered, Watson and Crick discovered DNA, that is not patentable, but Marconi invented radio, Graham-Bell invented telephone, someone invented electric bulb. So inventions are patentable. Discoveries that is already existing in the nature, we discovered it for the first time, that is not patentable. So patent is granted for an invention. It should resemble a new product or process. First time you are preparing a new product. New product means that product is not at all existing in the nature or anywhere in the prior art or literature. We are inventing it for the first time. That could be said as a new product. The second is new process. The product is already there in the market. We are preparing a new process to prepare the same product. And your invention should have inventive step and industrial application. These are considered as the 3 pillars of patentability: novelty, inventive step, and industrial application. If these 3 aspects are falling in your patent application, it will help you to convince the examiner and your patent will be granted.
Just a thought there, Prasad Garu.
Yes.
There may not be industrial application
So
in
utility
immediate future. Okay,
Yeah.
some patentable products have relevance for the industry, but not on an immediate basis. It can be a long-term one as well.
I'll clarify you here. Instead of industrial application, you see it as an application to the society. It should be useful to the society. Suppose you have come up with an invention that prints counterfeiting currency machine. It is causing serious prejudice and harm to the society. So that cannot be granted.
Yeah, usability is a better word. Yes,
Yeah,
usefulness is a better word. Not application.
It should be useful
Usefulness.
to the society.
Yeah, that's a better word.
Yeah,
Okay.
Useful to the society, then your invention is patentable, right? In terms of patentable new compounds. Suppose you are a life science candidate, then you would be able to know a new product or a process, I already told you, involving an inventive step and capable of industrial application. And discovery of a new form of a known substance. Suppose a product is already existing in the market and you have crystallized it, changed it from one form to another form, made some other form of a already existing product, that is not patentable according to the section 3D of Indian Patent Act. It is a highly debatable section. There is a big case that happened between Novartis and Union Government of India for a product called imatinib mesylate. So if you convert one already existing product into a salt, ester, ether, polymer, metabolite, pure form, particle size, isomer, mixture of isomer, complexes, combinations. So whatever you make, you could create from an already existing product until unless it possesses significantly improved therapeutic efficacy as compared to the already known compound. Indian Patent Act, according to section 3D, will not grant you a patent. If you provide some comparative data, existing product is this, the therapeutic efficacy area is like this, and the modified compound has enhanced therapeutic efficacy compared to the existing compound, then it is easy for the examiner to get convinced and grant you a patent application according to section 3D. So different claims, what you could claim: product, new chemical entity means first time that molecule is not existing in the market, first time it has been invented, then it is called as a new chemical entity. Formulation out of that product, combination, dosage forms, new form of a substance, you have to show therapeutic efficacy in India. The second way is claims of for process of method of manufacturing. So a method or process to manufacture the particular NCE you claim. Claims related to new property, new use, method of treatment. In India, these are not allowed, but in other jurisdictions, there is a provision, it will be allowed. So product versus process claim, a compound of Formula 1. So see how they have drafted a compound of Formula 1. They are claiming a compound. A compound is indicating it is a product. Just a second. Hello? Yeah. Yeah. Okay. Next 10 minutes. Yeah. Okay. Right. So this is the patent filing procedure in India flowchart. If you file an application, it will be published in 18 months. Then you have to request the examiner with the help of filing a request for examination. Then examiner will examine your application and issue FER. Then FER is first examination report. Again, you have to file a response with respect to the FER. If the examiner is convinced, he will grant your application. If he is not convinced, there is a chance to again ask you to give a further examination report. Sometimes hearing also, that stage also he could able to refuse. If he is convinced, he will be granting your application. There are provisions for pre-grant oppositions and post-grant opposition. If your application is published but not yet granted, you have some objections with respect to the published application. There is a provision to file a pre-grant opposition. Initial procedures, examiner will conduct a hearing and he will take a decision. If he is convinced, he will refuse the application from getting granted. After grant also, you notice that someone else has copied your invention and without intimating you, they have filed an application and it has been granted. After grant also, post grant opposition, within 1 year timeline of the grant, you could able to file. There also you have to provide substantial evidences to the examiner to convince them that it has been wrongly obtained or whatever. There are few clauses under this opposition. If you provide substantial evidences, the examiner is convinced, that time also the granted application will be refused. So this is the granted US patent application. You can see US is the country code, this is the granted number, and B2 is the kind code. Date of patent is, date of grant is this. This is the title. Applicant is CSIR. Applicant is the company name, you could say. Inventors means the inventors, whoever are involved in making this patent application are creating that invention. Assignee means applicant will assign sometime the invention via assignee. So here the assignee is also CSIR. We have not assigned to any other companies. Application number, PCT is filed. So this application has been enrouted from PCT route, PCT file, PCT number, PCT publication number. You could all see this abstract, 8 claims are there, 5 drawing sheets. So is traditional knowledge patentable? Traditional knowledge as such is not patentable, but we can play around that processes to make traditional knowledge or process for making that particular compounds that have been involved in traditional knowledge are patentable. As such, is not patentable. So if we all know that turmeric has some antibiotic properties, it is an age-old practice in India, and everyone knows it. It is already, invention is already in use. So already that is known to the public since age-old. We cannot say directly turmeric has antibiotic properties, give me a patent application. It is not possible. The other way is improved synthesis, a process for preparation of curcuminide mixture. So isolation process, chemical processes are patentable. Hello? Hello? Okay. ఓకే నాకు కూడా ఆఫ్టర్నూన్ మీటింగ్స్ ఉన్నాయి మరి ఒక 5 minutes ఇస్తే ఐ గుడ్ క్లోజ్ వాట్ డూ యూ సే ఓకే So, patentability aspects we'll discuss later. Different types of IP, we'll just have a glance and close this session as the other speaker is waiting currently and he is having other meetings, it seems. So let us go. Copyright protection is available for original works of authorships. Like primary goal is to protect time, effort, and creativity of the original creators. Copyright law protects the expression of idea, not the idea itself. Remains last for 60 years. What is covered? Paintings, literary films, dramatic, musical, artistic, sound recording softwares. What is not covered is ideas, facts, cooking recipes are not covered. Works that lack originality like telephone directory cannot be given a copyright. Names, title, short phrases are also not covered. So it helps and stops others to reproduce the work and prepare derivative works of the same work, distribute copies of any books or publications by sale, lease, other transfer of ownership, perform the work publicly, display the work publicly. So copyrights is lifetime of the author plus 60 years. Copyright in photograph, cinematic film, sound recordings is 60 years from the year in which it was published. Broadcast rights are 25 years. Performers right like mimicry, stage performing, 25 years from the beginning of the calendar year.
Sir, one quick question.
Yes.
Is that the derivative one which you mentioned, right?
Yes.
So supposing someone takes several photos or several paintings or pictures or something and uses AI to generate
Okay.
more, similar type style of photos, can that be called derivative?
So AI is again nowadays a drastically changing new generation thing. So how it resembles exactly from the original photography, that has to be matched and a clear interference has to be drawn. If still you could able to provide evidence that it is clearly your picture and they have copied and your picture has some quite demand in the market and it is giving you some as a painting or generating some revenue, then you could able to.
So supposing you were to take some samples of Lata Mangeshkar's voice and make her sing a new song.
Yeah, that cannot be done. There is quite examples recently also. Ilayaraja has sued all the playback singers. They are using their music in the stage public shows and collecting money for the events and playing the songs composed by Ilayaraja. Court has given in favor of him. So that voice and music rights cannot be done if the original creator has taken it lightly or with his permission and consent you have done, it's okay. Without that, then there is a high chance that original creators may sue you in the court. So literary works, these can be protected, you could see. Then trademark, a sign, word, letter, number, drawing, picture, emblem, color or combination of colors, shape of goods, graphic representation or packaging or any combination of the above can be protected as a trademark. It can be applied to an article or a product. It is a distinctive sign, symbol, logo, word. It can be sound, color, design or device which identifies certain goods or services. A trademark popularly known as a brand name of your business. Drawing, symbol, 3D signs, shape, packaging of foods, audible signs, musical, vocal, everything can be registered as a trademark. Trademarks are registered by national trademark registries and are valid in that country only. Period of registration is for 10 years and can be renewed indefinitely. Trademarks, a few examples I am showcasing you. GI, is the name or sign used on that goods originating from specific geographical origin or location and possesses qualities, few specific attributes related to reputation, characteristics, essentially to the place of that origin. We say Nagpur orange, Mysore silk saree, Agra peta. Because of that geographical origin or location, that product quality is being attributed. Then we could able to file a GI application with respect to that product. So here we have to see in India, geographical indications have to be registered. Only a society can register it. An individual inventor cannot register it. Who can apply? An association of persons or organization, authority under law representing the interest of procedures of concerned goods. That society is working in the interest of protecting particular goods. That society is eligible to apply. Any individual inventor cannot go and apply a GI. So registrar of GI, you can file an application. If anyone falsifies GI, imprisonment up to 6 months and 3
But
years.
how will they catch him? I mean, someone in Brazil starts marketing his rice as basmati rice. Then how they are going to imprison him or
So
fine
in
him?
India, you have to file a right there only. In India only, you could able to do. You file already. I told you all IPRs are subject to territorial jurisdictions. Wherever you have filed, there only it is enforced. Suppose you want to operate in Brazil, they have to file there also. Unless until they have filed some right in Brazil, they cannot stop other potential infringers,
Including GI.
including any IP. Right? Okay, few examples: Darjeeling tea, Kangra tea, Madhubani painting, Alfonso. So designs may shape, configuration, pattern, ornamentation, compositions of lines or colors. Novelty is judged with respect to soul eye. What you could register as design. Few examples. Trade secrets in India, it's not allowed. The few famous examples is KFC, Coca-Cola. We all know till date the formula behind manufacturing these products are not known. The original inventors have kept it in secretly a bank locker. Only 16 people till date know that formula. They are giving it to company. They mix it with some carbonated water. The product is being manufactured. So plant variety and farmers' right. Unlike Patent Act, there is a right for farmers to protect a new varieties. Their novelty, inventive step, and industrial application to protect it as a new variety. You know, novelty, distinctiveness, uniformity, stability is required. DUS we say distinctiveness, uniformity, and stability. Extent varieties. So persons who can register are breeders, farmers, universities, agriculture institute. Period of protection 15 years for annual crops, 18 years for trees and vines. Maybe Swapna Garu, if you are there, we could close. As you said, the next speaker is waiting. Hello? Hello? Yeah, I think I have done. Yeah. Yeah.
Sadhgaru, going back to your previous point on foreign, punitive actions, etc., there is something called extraterritorial jurisdiction (ETJ).
Okay.
Extraterritoriality is applied in cases where infringement. Okay, so it's a complex interplay of facts. The jurisdiction with regard to patent and patent violation is a complex topic involving several interplay involving facts that have an overall bearing. For example, there is a patented product in India.
Yes.
Related it, okay, in a different jurisdiction. We can
Okay.
then invoke the principle of extraterritoriality
Yeah,
Okay.
to
Srinivas
initiate,
garu.
but it is not
proceedings or action.
exactly IP related thing is not there. Extraterritorial jurisdiction, it is a legal power with respect to everything. It seems universal, criminal, different acts. Specific IP
Yeah, but
legal related.
Money
yeah. Can you just throw some light on that? I think IPR is also covered under ETJ. Maybe if you can show a different view with an example, that will be
Yeah,
appreciated.
till date, sir, successful examples I have not seen. If there is something happening, if you need to file a lawsuit, means definitely you should have a protection in that particular country. If you have not filed and you feel that someone is potentially copying your invention where you have not protected in that particular country, you have filed in India, someone is operating the same invention in USA, then maybe arbitration allows, you may approach court of law, everything is written in the prior art and that is appearing in my invention. Then that company may come to you with respect to some settlement agreement since they are using your invention without informing you. So hit and trial, and you approach a court and prove them that this is exactly mine, even though you have not protected in that country.
Prasad Garu, please, other speaker is waiting and we'll have the discussion at the end. Okay.
Right, okay. Yeah, okay. No issue. Since they have raised the question, I.
Yeah.
Right, okay.
The next speaker, Dr. Vijay Kumar Sahu. He is he is a regional manager and head outreach from National Research Development Corporation, which is under the Ministry of Science and Technology, Government of India. Sir has a vast experience, especially in commercialization of technologies of the research institution. So he has a practical knowledge on dealing with the commercialization aspects. Now I invite him to deliver the session on IP commercialization.
Thank you, Swapnaji. Good morning, all. Okay.
Very good morning, sir.
Yeah, can we have a introduction from all the participants since we are the limited participant? Yeah, Srinivasji, can you start from your side?
Yes, sir. Myself, Srinivas Madhupati, patent agent from Eeva Patent Services.
He is the
I know you.
speaker,
I
sir.
know you. Okay.
Thank
Then
The participants from the academic institutions and also one from research institution,
Swapnaji,
and we have
can you interact with them because
participants from Ayurvedic college also,
got
and
it.
many
Got
are
it.
PhD scholars, and we also have a participant from a Center of Excellence on cyber security. He's a CEO, so he also joined the session.
Yeah, I just wanted to interact because technology transfer, the topic is very, very vast and challenging, so that each cases or each officials who are part of the respective institution, what kind of technology they are developing or they are looking for, so that we can do the technology transfer. So I'll be happy to speak since I'm what we execute technology transfer, we do technology commercialization by doing all kind of value addition. So I'll be happy those who are there so that the talk should not be one side. There should be interaction, and technology transfer cannot possible from NRDC only if until unless the institution is ready or industry is ready, we cannot transfer the technology from lab to the land or mine to the market. So what kind of value addition we do in tech transfer process, because IP is as such not commercialization. IP is a strategy to create the value and extract the value. So I'll be happy to know the participant actually, so that will connect the dot and we can have a more opportunity in doing tech transfer, because this is the only bottleneck in India. Technology transfer and commercialization is not happening. So point is that whether market is ready, and if market is ready, whether business is ready, if business is ready, whether intellectual property is ready for the technology what we are going to transfer, so that Tomorrow there should not be issues of any IP infringement, copyright violation, plagiarism. So these are the bottleneck, and that's the role of IP. And in fact, when we are talking about technology transfer, so what kind of technology today transfer is going on in academia to industry, and what kind of technology today incubation process is going on in academics incubation center, and how state is playing an important role in leveraging technology transfer. Particularly, many state have institutional policy, state policy is there, organization have their own policy, but what the context of these people, those who are participant, they are looking from me, so that that can be ornament for their activity. So I wanted to hear from all the participants, those who are here, kindly respond to me. And until unless if you will not respond, I will not speak, because I am very particular on this kind of virtual program, because I wanted to know who are the participants, so that at the end of the day, the effort must not goes in vain. So I'll request the participant, those who are here, and I will request Swapna to kindly connect me to, maybe we need a minimum interaction, but maximum output should come out. And my presentation is full of information. That information also help you to create a regional ecosystem for doing technology transfer, because I will show some of the technology what we transfer in Andhra Pradesh, in Telangana, in Odisha. Last week we transferred one of the technology called HSP vaccine to Tech Invention Private Limited. How we leverage the technology from two national institutions by doing all kind of value addition, including IP protection, and that has been given non-exclusive license to one of the industry, and industry is going for a clinical trial. So I am looking forward to hear from you, so that we can discuss more and also deliberate more and connect the dot.
I think Srinivas Garu, please introduce not the speaker, the other participant.
Hello.
Yes.
Yes, I'm actually also doing the tech transfer with
Okay.
some of the technology companies,
Hmm.
like in Asian market. So I'm looking forward to your valuable points, which will be helpful for us to take into consideration while we're doing transfer from India to another country. So
Okay.
because it's, as you said, it's very important, and those are the
I'm
valuable.
not saying it's important. It's actually part of our innovation, which we are lacking in our ecosystem, because uh, India paid IPR royalties of 14.6 billion in 2024. That means India, when you are talking about Viksit Bharat, and if we are paying the royalty of IPO to the IP owner, in particular in the US value, and that was the quote of Amitabh Kant, the former CEO of Niti Aayog, that 14.6 billion India paid in IPR royalties in 2024. That means it is not only a challenge, it is a biggest challenge in our ecosystem, and that lacking in our environment for infusing technology.
Yeah.
Yeah, please go ahead, Kausalji.
Hello.
Yes, please go ahead.
I'm Sriram, Dr. Sriram Birdavolo. I head the Cybersecurity Center of Excellence here at Hyderabad, part of NASCOM DSCI, Data Security Council of India. So one of the key things we see is that the other countries are way ahead of us, China, Japan, so many of them, in terms of filing patents. So we have a challenge. We incubate about 85 cybersecurity startups. We have a major challenge that our startups don't find it necessary to file patents. Okay, for the speed, the client acquisition, whatever be the case, due to lack of funds, it's last on their mind, and later they will file or something like that. Maybe a couple of them here and there may file, but that is a constant challenge to get them to file. The other thing is that the rapid pace of AI, which has come up, with which ideas can be simply be taken, morphed, and given a new shape form in no time. Okay, including design, arts, everything. So there it is very fuzzy on what the intellectual property rights are, because it's almost as if all these IPR laws are like some ancient fossil, okay, outdated old laws which are there. Whereas these are moving ahead with a few clicks of button, you can generate off 1,000 designs, or do like that. Even consultants, let's say you've thrown in all the books of the world and it has sucked out from every book everything, including various organizations ones, and then you ask it questions, it will give you like an expert consultant using so many frameworks and so many things. So people are using it in every way which they can, and with every passing, why I'm mentioning this, that this is really becoming like an old bullock cart, is that if you see it, every few months there is a new LLM released. If you were to take Claude 4.5 itself, it is astonishing in terms of capabilities of how it can generate code. And if you take next Claude 6, I don't know what's going to happen to it. So that's simply going, blown it out of the ballpark completely into space. So that is where things are going. And are we really prepared to gear up, catch, and create and ride the wave instead of getting crushed by it, is the big question.
Completely agree, Sriramji, because let me just clarify you. In fact, we do not commercialize IP. IP is part of our technology transfer process, because since you are in your IT and software, I am not an expert on tech transfer in software industry, and we transfer the technology for manufacturing industry, and whatever the technology we do, we transfer the technology know-how, not IP. So let me also clarify you. And IP, as I'm completely agree with you, the challenge of IP protection in this sector, the sector where you are, and also challenge and bottleneck. I'm not going to comment on the IP part. So as far as the technology transfer part, from any form of technology today, when you are transferring from one industry, one academia to industry, because I was thinking academia industry tech transfer, but industry tech transfer through cross licensing or out licensing. Normally technology transfer happen in licensing of such technology, maybe exclusive and maybe non-exclusive. So how we do non-exclusive license, because being a public institution, normally we focus non-exclusive license, because we are transferring the technology from public institution. Exchequer money is there in the investment in public institution as far as the development of such technology is there. So how we do such kind of technology transfer, in hand holding the technology transfer, not just signing the agreement and close the deal. No, how we can leverage in that technology transfer process, from the signing of technology licensing agreement to validation, certification, demonstration, and commercialization. And in that part, IP is also one most important part, where we have to pay the annuity payment and IP strategy in supporting both the industry and also inventor. So that process we do, and particularly in your sector, in fact, I have a less knowledge, but certainly I completely agree with you the kind of challenges today we are facing. But in the computer related invention, Government of India under the Controller General of Patent Design and Trademark already came out with a policy, and that has been categorically demarcated the invention innovation for what kind of IP protection or software embedded with hardware can be patentable subject matter, software related invention, what should be the patentable invention, what should be the copyright invention, and what should be the trade secret and semiconductor integrated circuit layout design. So there is a provision in the Indian context. Indian ecosystem is already harmonized as far as the IP part, but tech transfer part, we don't have a national policy on technology transfer that every institution can cope with that kind of policy framework. But every institution like Department of Research Development, DRDO, has a their own IP tech transfer policy. We have CSIR, they have their own tech transfer policy. So institutional IP and tech transfer policy drives the technology transfer, so that in technology transfer, the biggest challenge is that how to manage the benefit sharing to the inventor and industry. Any inventor has created any technology, and that technology is going to the market. What kind of benefit sharing is there for the inventor as far as his and her intellectual property created by his lab or her lab, so that the revenue sharing can be also determined. So these are the bottleneck, these are the challenge, and particularly I got your point, but certainly I'll focus to my invention to innovation in the manufacturing industry. I will my scope is there, because we do tech transfer every day. We are dealing such kind of tech transfer and IP strategy activities. Thank you, Sriram ji, for giving your point, and certainly I love to respond to you in a professional manner. Yeah. Next, please.
Yeah, Vijay Kumar ji, I'm Srinivas. I'm an associate vice president in the Global Information Security Department of Bank of America at Hyderabad.
Okay, great, sir. Great to connect you.
Yeah, good to know you. And then my question to you this day would be that how do you check this practice of non-registration of patents or non-patenting of intellectual output by startups? And is there any incentive for startups to register or patent their intellectual output? And secondly, is there any mandate from the government of India to subject continuity of funding to registration or patenting of intellectual output? Is there any link between funding and patenting in the space of startups?
Srinivas ji, thank you. I am not the appropriate government department to respond to your question, but I will certainly complement to your question that there is no any kind of objective. But when any funding agency give any fund to any startup, certainly intellectual property protection is should be there, because
Ji, I can clarify his question.
let me clarify first, then you can, because I am the speaker here.
Yes, no issue.
So there is no clear-cut guideline from any department, but there is a policy. Let me bring to my some of my administrative ministry where I am basically coming from. When we fund to any startup, particularly under the MHI scheme, we run a capital goods funding, and also we give a technology development validation TDVC funding. So in the TDVC and this scheme, we try to come out with the IP, and also we handhold that IP for further validation and commercialization, because it is a strategy from our side, so that not only giving fund is not a thing. How we should handhold and bring a product to the market, that is most important, because we are giving exchequer money, and we must have to create a IP strategy. So many other such department, like in the defense ecosystem, we have a IDEX, those who are funding for startup. Startup India is doing. They have a SIPP scheme, Startup Intellectual Property Protection Scheme. They have a funding. They have a particularly subsidy for the startup as far as IP protection is concerned. Department of Biotechnology, we have BIRAC fund, many big funding. That is the Biotech Ignited grant to the startup while collaborating with the institution. So there are including other. METI is also having a IP part. So METI also plays a very important role, and METI looks after that IP part with their respective department, is also looking forward for that. In fact, we are part of METI funding, but not part of the IP strategy, because they have their own IP strategic group and institutional and organizational perspectives. So,
actually, I have a comment there is that when you do valuation of a startup, they take into account the patents.
yes.
Okay, so in their own interest, they should patent. Otherwise, their valuation will not go up.
As I told, intellectual property is nothing but creating value and extracting value and ownership. This is the normally we feel that if we file a patent, we'll get money. No, only IP is to mitigate the challenge of all kind of plagiarism, piracy, or infringement. Another is to respect the owner over his creativity in the form of invention, and that invention what we are protecting in the form of IP, in patent, design, trademark, copyright, and all form of intellectual property.
So basically, you're saying defensibility and commercialization.
Completely agree, and to respect the inventor, because this is, suppose Dr. Sriram has developed something. Tomorrow I can say, in fact, yesterday only I was in a engagement. Two scientists were there, Dr. Biswas and Dr. Who developed HSP vaccine. So I told both the inventor are here. Any query to that, you can speak to them because they are the inventor. They have a patent, and now we are going for international patent application because we wanted to get a more exposure of international tech transfer process. So point is that that is nothing but recognizing inventor over his creativity in the form of invention and an institutional ecosystem. Today any assistant professor have a patent and it got commercialized, it will also show in his and her credibility and the institutional credibility that some number of technology transfer has done or IP has been created. So IP is nothing but a right, that right for which we are protecting to our intangible asset in all this form, what my earlier speaker might have discussed on that part. And Srinivas ji, we can also you can take my number for Swapna ji, and if you need any bilateral support, you are most welcome. And let me also confirm you all that my strength, particularly in doing tech transfer, is manufacturing industry. We support in IP facilitation to the startup also, but I more into tech transfer in manufacturing sector. Thank you.
There is some panel which is see, here on the screen. There is something that is obstructing the view of the presentation.
Now,
yeah, that is fine now.
yes.
I still didn't understand one little question before we go on, that in tech transfer, why do you feel a separate policy is needed? What is the key point which for which it, because they will say that let every institution do on its own, let them share IP between the inventor and the market as they like.
No,
That
nobody is
their thing. Why
stopping
should the
also.
government?
Nobody is stopping for that also. But
Uh-huh.
the way we have a national IPR policy 2016, there
Uh-huh.
should be, let me also bring for your kind information, in a science and technology domain, Government of India Department of Science and Technology is also discussing for coming out with a national tech transfer policy, institutional. Because see, we have a IPR policy, and let me also inform you, government DPIIT has come out with a harmonized IPR policy at institutional level at higher educational institution. There is a sample draft policy. It is available in the DPIIT. Any institution can use that framework and make their framework accordingly, because that is a guideline and that is a benchmark for institution to have a IPR policy as well as the IP commercialization in the institutional level for granting research, sponsored research, and collaborating research, and also contract research. I hope you agree with me.
Yes, absolutely.
Thank you. Any more, please? Because this is I need this kind of clarification and also learning from each other, because rather than speaking in slide where there is no value, I think I love to be part, and I'm grateful that Srinivas ji is also there, Sriram is also there. So any Kaushal ji, do you have any query? Because you are doing tech transfer at industry level, let me also understand from your perspectives, and also how we can channelize in our ecosystem, since I am also representing one of the national organization doing all tech transfer, and also state has a policy. Many state have their policy, right now I'm heading at my NRDC office at both I mean south and east at present in Bhubaneswar. Government of Odisha has a policy. Any technology transfer in biotechnology, government of Odisha is supporting up to 1 crore rupees subsidy. For MSME up to 25 lakhs, there is a subsidy, and that too in the those who will take the technology from NRDC. In their policy, it is there. So such kind of opportunity, if we can create, even in Andhra Pradesh, government of Andhra Pradesh is also giving subsidy, and that's we are doing in Andhra Pradesh practically in leveraging tech transfer to MSME and startup. Thank you, Rajji, and we are honored to meet you also. Equally, we will get benefit, and such kind of query is not only a query that will the confident building measure and capacity building measure the challenges what the knowledge creator like you are also facing. And having said that, although I know I have a academic credential in IP, I did my PhD on intellectual property and including my MSc. But since you have asked the copyright concept, I sometimes I should not respond to such kind of question in public platform because it may be wrong at my side. But Rajiv, I will request you keep my mobile number and you can call me anytime for that kind of clarification. I will clarify, but you have to also cross check with a appropriate copyright expert. I am not a copyright expert in that part, content creating. But let me also tell you, sometime we support such kind of people, but that is the not our mandate, particularly in the poking our nose in that part. But we love to discuss with you further and take into the next level. And also, I will also connect you to appropriate agency or the expert, particularly on that part from the ministry or department, who can help you and also leverage without any hesitation and without any challenges. I hope you will understand, but I don't want to respond to, but I can give the some input on that part, but we'll discuss certainly off the record. Because I have a meeting with the secretary at 12 o'clock. So I categorically told that I'll be joining and finish it up. But I love to be part of it. So I'm looking forward for the discussion. Rajiv, Swapnaji will share my mobile number to you. So having said that technology transfer, you can see in my slide both, and the lady who is standing left to me is the lady from Hyderabad only. She is the managing director of the one of the company, and lady who is standing right to me is from a national institution and the scientist who also superannuated from Government of India 2 months back, but she got, I think, extension because of this kind of invention innovation they have created. So they have developed this product from marine chlorophycin algae, the lutein from marine chlorophycin algae, and it is very very nutraceutical. There is a demand, and the industry, the lady who is standing left to me is a postdoc from US, and but he wanted to establish a company in Hyderabad, a biotech company. And this technology we transferred to her, and you can see how the bringing confidence, loyalty and trust. So that's the role of intellectual property. Somebody will invest, somebody will trust, because there will be a intellectual property readiness level, market readiness level, technology readiness level, and business readiness level. Then only we can do a technology transfer. Otherwise the technology transfer and commercialization may not succeed. Only we will deal or sign the agreement in the form of licensing agreement, but the technology or the product will not shows the light of the day. So this is the crux of my talk. And in fact, we support in handholding technology transfer. As I told Rajji, recently we transfer HSP vaccine technology to one of the industry. You can see how we are bringing academia, industry, government, and also industry together in transferring technology by doing all kind of value addition, including intellectual property protection. So we have many number of innovative technology. And let me also inform you, we also support up to 70% of the technology transfer fees we reimburse to the MSME, because we have a technology transfer facilitation center given by Ministry of MSME. So with this, I have to stop because I have another engagement. I am looking forward to connect you. We took industry to the various ecosystem of innovation so that they can learn, relearn, and also adapt the practice of tech transfer. Fortunately, recently I had been to Israel, saw many of the Israel innovation activity. We are leading it in transfer for bilaterally, internationally, and also nationally in the national ecosystem of innovation. And these are the some of the technology during the corona we transfer and commercialize in the tracing, testing, and treating of COVID-19, and also supporting to women entrepreneur for validation of such kind of new product and innovation by doing a technology development funding, and also product development funding. and leveraging technology transfer, giving technology to the women, particularly infusing to their business practices, and hand holding to the cluster. And these are the technology we transfer during in the strategic area in the recent time. So friends, I have to stop here. My mobile number, email ID is there, and you people can also connect me and discuss with me further, so that we can strengthen ourselves in mitigating the challenge of global arena by infusing technology in our business practice. So mobile number, email ID is there. Thank you for giving this opportunity, Swapna. So as per
Can
the
you
time,
please
your
share
time.
these slides?
So my PPT I will share, but some of the PPT I will not share because these are strategic. Some of the technology are there for thing, but I certainly will love to share with you, sharing and caring. God bless you all. Jai Hind. ओके, अभी सीईओ के पास जाएंगे हम. So please allow. I need to leave. I have another engagement.
Okay,
Thank you.
thank you. Thank you. Okay. So we have the next session. Though Sahu sir was invited to brief about the commercial aspects, but I think he has spent time in introducing and asking about the inquiries relating to the commercialization aspects. But we have the next speaker who is also expert in dealing with the commercialization, and I invite Srinivas Madhipati Garu, who is empaneled with NIMSME. So he is providing services relating to the IP registration and also commercialization. Now I request him to deliver the session on the IP commercialization and how this technology readiness level will be done, how the support has been given to the MSMEs especially, and he will be also highlighting some of the case studies, cases that how IP strategy has helped the MSMEs to generate the revenue and enhance the competitiveness, especially while entering the product into the market, how they could take these steps in placing their invention. So I invite Srinivas Garu to go ahead with the session.
Thank you very much, Swapna. Thanks for all joining today. Good afternoon. Before I begin, I hope like the screen is visible, right? I'll just actually make up this session commercialization strategies because like Dr. Sahu Garu is not having much time. So before I begin, I would like to sincerely thank the earlier speakers for their insightful and engaging presentations. So their perspectives have set a strong foundation for today's session. Let me take a few minutes to talk about commercialization. One important point I want to make very clear is this: IP registration or a granted patent does not automatically lead to commercialization. So many startups or MSMEs assume that once IP is filed or granted, business will flow or business will follow. That usually does not happen. So commercialization requires planning, ecosystem support, and structured engagement with industry. So in the next slides, I will briefly explain that actually helps IP move from paper to practice. One of the strongest drivers of commercialization is industry and academia collaboration. Academic institutions are very strong in research and idea generation. Industry is strong in product development, manufacturing, and market access. When both work separately, innovation moves slowly. When they work together, research moves faster into usable products. For MSMEs and startups or the institutions, collaboration with academia helps reduce development cost and technical risk. For institutions, it ensures research leads to real-world impact, not just publications. So they can reduce the R&D cost as well by getting grants from the industry. Collaboration works only when it is done properly. So projects must be problem driven, not only curiosity driven. So industry problems should guide research objectives. Most importantly, IP ownership and licensing terms must be decided at the beginning, not at the end. If IP clarity is missing, even a good technology will get stuck. Clear expectations, early um, planning for commercialization will make things smoother at a later stage while while working on the innovation. So this is where technology transfer offices like TTOs, we have one technology transfer office in Hyderabad, in IIT Hyderabad. So this has been funded by different departments. This is where technology transfer offices, TTOs act as a bridge between inventors, institutions, startups, and industry. They are not just like the NRDC Center is also one of the technology transfer office, and which is in Vizag. So it's not only for Andhra Pradesh or Telangana, it's whole of India, and one office specifically for industry in Telangana we have at IIT Hyderabad. So these TTOs act as a bridge between inventors, institutions, startups, and industry. They are not just administrative offices. They help identify which IP has real commercial value. They support in licensing and technology transfer. They assist in negotiations with industry partners. So for MSMEs and startups, TTOs provide structured access to research outputs without confusion or delays. Commercialization improves when incentives are aligned. So incentives for inventors and institutions are aligned. Inventors should be encouraged not only to publish, but also to patent, license, and participate in startups. That is the objective of TTOs being set up. Institutions must have clear revenue sharing and recognition mechanisms. When inventors see value in commercialization, participation automatically increases. So incentives change behavior. This is a practical reality. We have some good last 1 year, 1.5 year, like we have good examples where like the TTO or the technology transfer offices helped startups based out of Hyderabad, based out of Telangana. And there are very good success stories. I wish to share some of them towards the end of the slides. Some best practices is like first, early evaluation of commercial potential. Not every idea needs a patent. Second is simple and transparent IP process, like need to reduce the complexity which discourages innovators. Third, access to funding, mentoring, and facilitation schemes all are available these days. So when these elements are in place, IP naturally moves towards commercialization. We have three IPFCs under MSME, and you all know like Swapna Garu is discussing about Startup India IP facilitation scheme. So we have a mechanism in place to access IP facilitation, means like accessing the professional services to file and get the prosecution of patents, trademarks, copyrights, and designs. All that the enterprises or startups or MSMEs has to do is to identify the IP within their pipeline of developing the product. So we'll discuss about the TRL levels in next few slides, where and when the IPs need to be identified or maybe start to file and then need to target monetization and commercialization. So let me summarize the commercialization slides. So to start with within the next part, my today's session. So IP alone does not guarantee commercialization. So collaboration structure and incentives matter. When industry, academia, institutions, and innovators work together, IP converts into real economic and social value. So that is the core idea behind effective commercialization. In short, commercialization succeeds not because IP exists, but because the ecosystem supports it. So give me a sec. So I'll just open my another slide. So I will not repeat what IP is here. So my focus today is very practical. At what stage should you use which IP and why? So because in my experience, businesses usually fail in IP not due to lack of innovation, but due to wrong timing and wrong strategy. So let me start with a simple reality. So many startups either file patents too early when the idea is not mature, or file too late after already disclosing the invention, which both are dangerous. Technology readiness level or TRL gives us a decision framework. It helps us decide when to file IP, when to disclose, when to invest, and when to commercialize. IP should grow along with the technology, not before or after it. I will briefly recall the TRL structure. So, technology readiness level or TRL is a way to understand how mature a technology really is. It does not tell us whether an idea is good or bad, and it does not tell us whether it will make money or not. TRL tells us only one thing: how close the technology is to real world use. For startups and MSMEs, this is extremely important because many problems happen when an idea is treated like a product before it is actually ready. TRL gives a common language to innovators, investors, government bodies, and industry partners to judge the risk around the product or the idea. The most important thing to remember is TRL is not just a technical scale. Each TRL has different risks and therefore requires different decisions, not only in product making or in engineering, but also in investment, disclosure, and intellectual property. When technology maturity and business decisions move together, commercialization becomes much smoother. At TRL1, the work is still at the level of basic principles. At this stage, the activity is usually literature study, research, and hypothesis building. For inventors or founders, this stage is often informal. The biggest danger here is early disclosure, such as publishing or openly discussing the idea without thinking about the future protection. And at TRL2, the concept becomes clearer and the innovator can explain what problem the idea is trying to solve and how it may work. There may be concept notes or some kind of a initial work being done in terms of drawings or maybe in terms of very pre-stage prototyping or something like that. So many startups are active at this stage, pitching concepts and talking to mentors. The reality is that at TRL2, you know what you want to build, but you do not yet know whether it will actually work or not. At this stage, do not rush to file patents or IPs. You may not even know yet what exactly is patentable at this stage. So your IP strategy here is about control, not filing. And for the control measures, like you can use NDAs before discussions, trade secrets, like means not disclosing core logic to anyone and everyone. you may actually file certain copyright applications for the drafts or the early software or something like that. You can register your domain or maybe file a word mark, trademark application for the word that you want to have it as a brand for the company name. So this stage is about who knows your idea, not about how many filings you have done. So TRL 1, 2 is the stage that is the stage to control the information within the people, within the two or three co-founders or the inventors, not expressing the idea or the product itself. TRL 3, the technology reaches the proof of concept stage. So here, critical parts of the idea are tested individually, usually in a lab or controlled environment. Maybe the innovator can now say the concept works in principle. For startups, this is often the stage where a basic prototype or algorithm starts showing results. However, this stage is often misunderstood. A working proof of concept does not mean a working product. And at TRL 4, maybe multiple components are integrated and tested together in the lab. The system may begin to look more complete and demonstrations become possible. Technically, this stage shows that the system works as an integrated unit, but still under controlled conditions. For many innovators, this stage creates overconfidence. It is important to understand that TRL 4 means lab validation only, not real world readiness. This is the right time to file maybe a provisional patent. But again, one need to understand that the provisional patent can only lock your priority date. It cannot be enforced. So again, disclosing the whole of the invention to the investors or maybe anyone else is a risk. And one more thing, do not put everything into the patent. So whatever the inventive aspect or the invention itself or the improvement that you see out of your TRL 1 and 2, the prior risk and all, when comparing the existing product or the service or the technology, whatever is the inventive aspect that you need to disclose or you have to put it into the provisional patent. Because putting everything into the patent later at a point after 18 months or maybe through early publication and all, so the information that you put into the provisional patent will be published. So you have to have only the core technical concept, not the algorithms, not the formulas, not the data processing logic, or maybe the different ways of doing manufacturing of the product, which are not required to support the claims that we wish to make when we file the complete specifications. So these need to be avoided in while filing the provisional patents. So this balance gives you flexibility and strong protection through your patents. At TRL 5, the technology moves closer to reality. So the prototype is tested in a relevant environment that resembles real world conditions. This could be a pilot project, simulated field conditions, or limited user testing. For startups, this is often the stage of first customer pilot. This is also a critical failure point because real world conditions expose problems that never appeared in the lab. At TRL 6, the technology is demonstrated reliably in the relevant environment. The prototype is no longer fragile and performance becomes repeatable. This is the stage where vendors, partners, and early customers start taking interest seriously. From a business perspective, TRL 6 is where commercial discussions begin. If the system repeatedly fails at this stage, it is not yet ready to move forward. So you have to come back to TRL 5, 4. Customers, vendors, employees, and partners are involved here and your risk increases. At this stage, one IP right is not enough. You must start building layers. You must be filing your complete patent applications for your provisional applications filed for the technology. You must start filing design registration for product appearance. You must start trademark filings for your logo in relevant classes, in additional classes, etc. And you have to take IP assignment agreements from employees and vendors. So before actually engaging them, this combination creates what we call an IP moat for the startup. And at TRL7, the system is demonstrated in an operational environment. So the technology is now very close to the final product. Most components are in their final form, and the system can perform its intended function under actual working conditions. For startups, this is a pre-commercial stage where scaling discussions, licensing talks, and regulatory interactions may start. Example, a medtech startup licensing at TRL7 is possible. At TRL8, the technology is complete and qualified. All testing is done. Certifications or regulatory approvals are obtained where required. And the system is ready for production. From a startup point of view, this is the stage where manufacturing, supply chains, and go-to-market strategies are finalized. The technology itself is no longer the main risk. Execution becomes the focus. Now we talk about licensing, partnerships, joint development, and foreign markets. The earlier speaker actually is talking about the PCT and PCT national filings. For your provisional filing, based on provisional filing, if you file a PCT within 12 months, so you can think of actually filing your PCT national phases, because like this, ideally it is between 18 to 30 months when you come to this stage. Here, patents help in valuation. So trademarks help in market trust. Contracts decide who owns improvements or who owns the IP. If you are actually working with an institution or working with another industry, a manufacturing partner or someone. So many startups lose IP value here due to poor agreements, not weak patents. So the patents may be in place, but because of the poor agreements they make between the parties, so they lose IP value. Like the counterpart may dispute asking for IP right. So many startups lose IP value here due to poor agreements. So need to be very cautious here. And TRL9 means market entry. So at TRL9, the system is proven in the market. The technology is used by real customers in real conditions and generates value. At this stage, competition becomes visible, copying risks increase, and long-term sustainability becomes important. For MSMEs and startups, TRL9 is not the end of innovation, but the beginning of lifecycle management, improvements, and expansion. IP portfolio management is very important from TRL 8-9. So now IP is no longer theoretical. It protects revenue and reputation, and it should become a habit in the organization. At this stage, trademarks often become more important than patents. Monitoring infringement matters. So IP watch, trademark watch, patent watch, design watch are very critical. And doing freedom to operate studies when you are actually thinking of entering into new markets or engaging new channels, it is very important. Like you have to think of doing or having a policy or procedure to do often FTOs. Renewals and enforcement are critical. So renewals are very critical. Filing of certain forms, informing the patent office about the working of patents is very important. Enforcement is very critical. Like you have to start enforcing if there is a risk of copy or maybe infringement of your technology by any other competitor. So improvement patents can extend life cycle. So the startup or enterprise can think of actually filing improvement patents over the existing patents. So strong IP here supports long-term business sustainability. So this is how like the planning need to be done. So if you remember only one slide, so remember this one, each TRL has a primary objective. So early TRL has a primary, like early TRL is of controlling the information. The mid TRL securing the priority, filing provisional patents, and maybe registering the domain names, filing initial trademarks, some trademarks, and filing some copyright applications for the code and the architecture and all. And the later TRLs, like it's about monetization and defending. So you have to start enforcing the rights that you have. So IP works best when it is aligned with these objectives. So this is where like the TRLs aligning with IP strategy is very important for startups and innovators. So key takeaways for MSME startups and inventors. So IP is not paperwork. IP is not only patents. More filings do not mean stronger protection. The real strength comes from correct timing, correct mix of IP, strong contracts, and disciplined execution and maintaining of IPs. Always let IP maturity grow with technology maturity. So successful commercialization happens when technology readiness and IP readiness move together. Not only technology readiness, not only IP readiness. So they have to move together. I'll stop here if we have some questions. Like I hope like I'm just hurrying bit because like I have more slides and I have 2 topics to cover. And again, I have a limited hard exit to be made. So at around 1 p.m. So
So
any
I hope
questions?
you can share these slides.
I do. I have a note file actually, and as well slides. I'll definitely share with you. And under MSME IPFC and other IPFCs we have, like we are actually actively supporting MSMEs and startups here in Telangana, based out of Telangana. So NIMSME under the leadership of Mrs. Swapna Vanmala, she's doing a great job. So we filed and successfully prosecuted a few applications recently, which actually are successful in getting certain fund as well in through government schemes as well, the private equity. So I'll share some success stories where like NIMSME IPFC handholded these startups, these enterprises, I should say. Some of them are startups, some of them are 6-7 years old entities into life sciences, into deep tech, into defense and other technologies. So that the
But
yes,
one question is that there are product patents and process patents, no? So
yes,
all what you have mentioned holds for that also, process also.
yes.
Okay.
So yeah. So this is one of the startup. It is Startup India recognized, and it has first this startup first won Bayrak big seed fund initially 2019, and then recently they got a fund from Technology Development Board. So this is a very good example of IP filed at exactly the right time. So how the life sciences is a life sciences startup. They developed a new drug delivery approach for treating respiratory infections. So they took known compound or drug, I can say, but actually tried a new delivery method for the respiratory infections. So at the time they filed their patents, the technology was at TRL 3-4. So the proof of concept was validated in the laboratory, but clinical trials had not yet started. Instead of waiting for advanced validation, they took a strategic IP decision. They filed patents immediately after laboratory feasibility, well before any public disclosure or clinical data generation. Importantly, they did not try to patent everything. The core delivery concept was protected through patents. while sensitive formulation parameters were deliberately retained as trade secrets. Because the IP was secured early, the startup could confidently approach government agencies and investors. This directly enabled government funding support, international patent filing, and a smooth progression into advanced clinical trials. Recently, last month, we filed their PCT national phase applications in USA, Canada, Europe, China, Japan, and Australia. So the key lesson from this case is very clear. So patent filing should happen once technical feasibility is clear, not after full validation or commercialization. This timing protected both innovation and future opportunity for the startup. So we are happy for them from NIMSME and whole of the IP facilitation ecosystem. And this is another example. So the space and deep tech sector, and clearly shows how IP filing at the right TRL builds investor confidence. Eon Space Labs worked on a miniaturized telescope-based imaging system designed for CubeSats. At the time of IP filing, the technology had moved beyond concept and was validated through laboratory integration and pilot level testing, placing it around TRL 4 to 6. The key decision here was layered and timely protection. So they filed patents to protect the core optical and imaging technology and simultaneously secured trademark registration for their brand identity. This ensured that both the technology and the market identity were protected before serious funding discussions. Because the IP position was clear and credible at this stage, so investors were not evaluating just the idea, they were evaluating a defensible innovation. This played a direct role in enabling successful pre-series funding for this startup. So the lesson from this case is straightforward. At TRL 5-6, patents alone are not enough. Layered IP, patents plus brand protection significantly reduces investor risk and accelerates the scaling up of the entity.
So one question,
Yes,
this
sir.
entire Europe is treated as one region, is it, for patent?
Yes, sir. For patents including UK, but for trademarks excluding UK.
Okay.
So this is another a success story. So which NIMSME handholded this entity. It's in defense and security domain where timing and breadth of IP protection are especially critical for this startup. Onayan Defense Technologies, so an IITH incubator, developed a non-destructive counter-drone solution that captures hostile drones rather than destroying them. This is an RFP from the defense itself to catch hold the drones, not to distract. Means like there is an existing system which is called hard kill for hostile drones, which like the drones are been tracked and been fired. So the soft kill and hard kill both are used in Operation Sindoor. But there are certain errors actually happening with hard kill or soft kill. Means like our own drones or maybe some other infrastructures are also being damaged with this approach. So what the defense has a requirement is like they have to catch hold of the drones. Means like we need to bring down the drone without actually destroying it. So this has been taken and they are actually selected for the pilot project doing. So Onayan Defense Technology. At this stage, the founders made a very important IP decision before actually they are displaying or maybe field trying the product. So this is the image that you can see in the Defense Expo last year, 2025. So separate patents were filed covering the projectile system, the net deployment mechanism, and the AI-enabled fire control system. So in parallel, the brand identity was also protected through trademark registrations. So this ensured that not just one component, but the entire system architecture was protected as the technology matured. So because of this structured IP approach, the company could confidently engage with defense agencies and strategic stakeholders. At TRL 5 and 7, especially in defense technologies, portfolio-based IP protection is far more effective than a single broad filing. So this need to be taken care.
So, Srinivas Garu, I just have
Yes, sir.
a couple of questions here. Number one, um, is there any IP audit that takes place
Yes.
to verify
At each
the
stage,
compliance?
actually, the IP audit need to be there, sir. So starting from TRL 3, so we need the entity or the startup has to have an IP audit. So internal IP audit, or maybe taking help of a patent agent or a professional who can actually do the patent analytics. Not only patent analytics regarding the brand name or the brand names that they are actually thinking of. I'm not only talking about the deep tech or maybe defense or maybe a pharmaceutical thing. So it can be a consumer products or consumer durables as well, or a cosmetics brand as well. So they can have they have to have an IP audit at each stage, maybe scheduled every 3 months or 2 months.
At which stage you said? TR3?
Starting from 3, sir. 1 and 2 is obviously validating the idea.
Okay.
So we are not sure like whether we can have a patent or maybe file a trademark is too early. If you have something related to trademark or maybe some website need to be developed, that can be maintained as trade secret, and then there is no need of actually going and filing. But starting from TRL 3, 4, so an IP audit need to be there every 2 months. I suggest, and yes, it will be suggested by everyone. So some suggest every month as well, based on the time they are actually taking for each stage, evolving from the 1 to. So
What about non-disclosure agreements, NDS? What about non-disclosure agreements?
It should start from TRL 3, sir.
Okay.
Yeah.
All right.
1, 2,
Thank
if
you.
you are 1, 2, I say like we are not discussing with anyone. Only we are discussing with 1 or 2 people, maybe a mentor or an organization which is actually incubating us. At that point in time, also we need to have an NDA with them. So, but actively, when 4, 5, 6 comes, like when vendor comes, when a third party comes in, when a app developer comes in, when employees comes into the startup, there like NDAs are very critical.
Okay, just a general question, Srinivas Garu. Are patents filed on foreign soil? I'm sorry. Are patents filed on foreign soil? Are they in India? Patents filed on on foreign soil, meaning in foreign countries, are they considered taken due consideration of on Indian soil?
Yeah, assessing the invention. While assessing
Or
the novelty
Yes,
of
sir.
any application.
do they need to be refiled here?
They are not directly enforceable, sir. Yes, need to be refiled,
Refiled
sir.
on Indian soil.
IPs are territorial, sir.
Okay, okay.
Yeah, IPs are territorial. All IPs are territorial,
Yeah.
and
I think that applies here.
except
Okay,
the
got it. So they have to
yes,
be refiled on Indian
except
soil.
the
Okay.
yes. Even in the case of group filings, for example, Europe as a whole, application can be made EU patent office, but after prosecution, after patent grant or after trademark registration, the renewals need to be made independently again each country. So means purely territorial, even in the group applications also.
Even for PCT.
Yes, sir. PCT, sir. PCT is only like it's a application filing convenience, sir. So we can actually express our interest to file our application in all the countries through PCT initially. Within the 31 months timeline, we have to file our national phase applications. Means like the application will be reached to the patent office with an interest saying like through PCT, like he designated the particular country, but the applicant has to make an application within that timeline. So So the next example comes from the quantum and advanced AI domain, where ideas move very fast and early disclosure can permanently destroy novelty. QAIG Quantum AI Global is the company name. QAIG worked on a hybrid AI-driven laser locking system for quantum sensing and precision applications. At TRL 3 to 5, the core mechanism was validated in the lab, but wider system integration and deployment were still in progress. At this stage, an AMSME handholded few applications for this startup. So this is the yesterday's news article about the startup. So driving India's quantum tech revolution, QAIG, through their different products. So this is the success story of this startup. And the next one is the electromechanical and e-mobility domain, where many innovations are incremental but highly valuable. I'm showing only examples from the entities based in Hyderabad, Telangana.
You had mentioned that early disclosure can destroy what?
Destroy our chance of getting a right, sir. So earlier disclosure before filing a provisional patent or a complete application, so will become a prior art for us. So even it can be our website article, our own publication. So even the institutions like the academic institutions, the R&D institutes, like they prefer actually publishing something, though they won't actually give much detail or validation results in the publication, but still it becomes obvious to the patent application, which if it is filed later.
So you're saying you discourage that?
Yes, 100%. We need to, if we are thinking of actually having an IP on the work that we are actually doing, so first we need to file a patent if it is patent eligible, and then we have to proceed with the publications. So these vector techniques worked on an integrated cooling system for BLDC motors and a flywheel generator assembly. At the time of IP filing, the technology was at around TRL 4 to 6. The concept was validated and prototypes were being tested for efficiency and durability. So the one important thing here is like it's not an disruptive innovation. It's an incremental innovation in this case with vector techniques. Instead of treating this as a small improvement, the company took a strategic IP approach. They filed separate patents covering complementary aspects of the innovation, the cooling integration, and the generator rotor architecture. Rather than one generic filing, they filed separate IPs, and they got a few grants as well. So this allowed them to protect engineering know-how that competitors would otherwise copy easily. And they got an investment from a defense manufacturing company, again based in Hyderabad, a 4 crore amount. So for a dilution of 20% equity, actually they got recently. So the key lesson from this case is very relevant for MSMEs. At TRL 5.6, improvement patents significantly extend the commercial life of a product. So I recommend at TRL 5.6.7, we need to think of actually more innovations or the substitute innovations or the substitute improvements that we can actually tap to file IPs, which will give a better value. And we have one more case, again, AI and applied intelligence domain. So this Sentinel developed an AI core that could be applied across different use cases. So developer training, agriculture, and wearable safety systems. At the time of filing, these applications were at TRL 3 to 6, depending on the use case. Instead of filing single broad patent, the startup made a smart IP decision. They identified distinct application-specific innovations and filed separate patents for each vertical, even though the underlying AI philosophy was common. So this approach allowed them to scale the same core capability into multiple markets without weakening claim scope or mixing disclosures. But we made a strategic a good approach where we filed all these applications at once, because again, our own publication will become a prior art. So the logic is same, the AI architecture is same, but the applications are different. So that like we had to file all the applications they want on a single day at once. So not to have one as a prior to the other.
How much does the process cost, the whole patent process, to file one patent?
With IPFC or Startup India facilitation, you don't need to think of actually costing, sir. You have to only pay the government fee. So government fee is approximately, including the early examination, early publication, it is approximately 13,000. So 13,000 you have to pay, and you can avail the scheme. One of the scheme, if the entity is a startup, if the entity is an MSME, both are eligible. In case like if it is an education institution also, the NIMSME will support for their applications. Means almost everyone is supported here, apart from natural person applicant. Even natural person applicant can also register a small MSME, saying like my objective of this MSME is to develop some product, commercialize it through licensing. So that is also possible. Means all are eligible under the scheme to avail the IP facilitation schemes through DPIT Startup India or through MSME IPFCs. So normally, apart from like the scheme, normally the cost starts from around 15,000 for the search stage. For the drafting and filing, maybe like different firms charge different, but starting from 30,000 to 50,000 for the filing stage, provisional filing and converting it into complete application. And then after that, like there are two stages: the first examination report, and may go to a second examination or the final stage of hearing. And again, that there like firms charge 15 to 25,000 each stage. So approximately 1 lakh rupee end to end for filing and prosecution uh, uh, is the market cost. But the same like you can actually avail under the scheme by only paying the government fees.
Yeah, but then the government itself, you may have paid the government fees, but you still need somebody to draft it very carefully, right?
Yes, yes.
So all the other fees will be for that.
Yeah, the government, and for example, NIMSME has patent agents empaneled. For example, I myself, I'm an empaneled facilitator. I have experience working in defense, deep tech, mechatronics, robotics, engineering domains. And we have other speaker after me, like Mr. Vijay Bhaskar Reddy. He's into food technology. He's into biotechnology. So he's a specialist in drafting pharma, chemistry, biotech, food technology patents, biomedical as well. And also Swapna Vanamala herself is a patent agent. She's MTech graduate. So she is actually drafting herself some applications. So we have a panel of IP facilitators, and even at DPIT Startup India also, all the patent agents are eligible under DPIT Startup India facilitation scheme. Means you can approach any patent agent, you can vet their background or maybe qualification and experience, and then you can ask them like, I'm a startup. They cannot deny, because all the patent agents are directed by patent office itself to act as IP mitras for startups coming to them for facilitation purpose.
Sure, sir. Please do share your contact details.
Yeah, sure. And this is an important small innovation in terms of the technology wise. So it's a learning tool which is made by a primary school teacher, government school teacher. So it is for the primary school going kids. So learning of language, it can be Telugu, Hindi, Tamil, or maybe any other language, including English. So they can use this slate, so which has a three like there is a top grid, a left and right grid, where like they can actually make a matchmaking. The students can make a matchmaking to write words, to learn words, writing words. So this, we recently got a grant last month. So ultimately, like there was an objection related to this is in design aspect rather utility aspect. The key objection is that we somehow actually managed to get it. Yes, it is true. We know it is a design aspect. So we filed a design registration also. But for his strategic benefit, for his product benefit, for his startup benefit, for his entity's benefit, We tried actually filing a utility also, and luckily we got a utility patent as well. Even the patent office, based on the usage, based on the applicability, industrial applicability, what we call the third aspect of patent, third aspect in granting a patent. So based on the industrial applicability, the controller accepted this application and gave a grant. So we now have a trademark for it. We have a design for it and a patent for it.
Okay. And then
The key lesson from this case is extremely important for startups working with government or education systems. Just file IP before widespread adoption, not after success becomes visible.
Okay.
And the last example I'm taking is related to energy systems. So this is we filed 4 applications, facilitated him 4 applications.
I knew that.
We got 3 grants already. So Veerabhadra Elite worked on a high voltage direct current generation system that solved a complex engineering challenge. So synchronizing multiple generators to produce stable and directional output. So when they approached for IP protection, the technology was already at TRL5 with a working prototype, but not yet fully commercial. Instead of waiting for market deployment, they filed a patent covering the core system architecture and some synchronization mechanism. As the technology matured further, they followed this up with international filings as well. We supported him for PCT filing as well. We are supporting under IPFC up to 50,000 rupees, because like an entity filing a PCT application costs approximately 1,50,000. The government fee itself is 1,500 USD. But as we have to cater to more number of applicants, so we had a cap on the PCT filing cost. So under MSME IPFC at NIMSME, we have supported this entity for all his 4 applications, Indian applications end to end. But for his for his PCT applications, we are supporting him up to 50,000 each application. So that's it from my side. So any questions like related to mapping the IP strategy with TRL, or maybe some of the success stories that I've shared, or related to the scheme modalities also, like you can discuss, or maybe we can discuss. We have a last session also, which will be by Swapna herself. So discussing the benefits or the IP facilitation that the NIMSME is actually providing.
Just one question, quick question, is that how long does it take? You said you're filing about 1 lakh rupees, 1 point, but time duration to get
with early exam. Yes, sir. With early examination, we are seeing results within 10 to 12 months. But we have to optimize the time. Means like we should not file provisional and wait for some time. Though it is allowed for 12 months, it's something like we have to cut down that time. So we have to file our complete specification, and from date of complete specification, you can take 9 to 10 months as the lead time for a disposal of the application under early examination. And early examination is possible for institutions, government institutions, MSMEs, startups recognized under DPIT, and also natural persons where like one of the applicant is a woman. So all these 4 categories has early examination. If not early examination, it will take at least 3 years.
Okay. I see. So you're mentioning this for one country, that means in India. Supposing the other country's PCT is there, then each one will take its own time, is it?
Yes. There is no need like we have to file a PCT definitely. So if we have, for example, if we have an invention, we know it has potential. For example, this invention which I am showing, this has potential across countries. So there is no need of actually filing a PCT. We can, after filing an application in India, by properly doing our research related to prior arts, differentiating them with our invention. If we are confident that we wrote a very good application, then we can actually directly file the respective applications in those countries which we are looking at. So
it will be costlier, right?
PCT is obviously. So in terms of cost, India is the cheapest one, because approximately 13,000 is the government fee, and you pay yourself, like it is approximately 1 lakh rupee, including the government fee, end to end. And the same, like if you compare with any other country, maybe Sri Lanka or those countries, Nepal and all, very cheap. It's not very costly. Same equivalent, even cheaper than India. But finding a right person to represent our case is a bit costly. But when compared with India, yes, again, approximately in 2 lakhs, you can get a patent grant in Nepal. You can get a patent grant in Sri Lanka and in some countries like this, Indonesia and all. But other countries, for example, Japan, China, so we need to have a translation first done in their language to be filed, because they accept the English application, but they want a copy of the copy translated in their own language, technical translation. So right from there, like engaging a person, engaging a translator, engaging a patent attorney, and then even the government fees. Government fee is approximately 900 in including the examination fee. In China, it is 900. In USA, it is 730 for a small entity. If it is a micro entity, it is 430 USD. So the next country after India, cheapest in terms of like IP value, it is USA. So
And
we can
Europe?
get an application filed for around 1,200 USD after filing in India. And even in prosecution also, it may cost you around 2,000 to 2,500 USD. Means like in 4,000 USD, approximately in 4 lakhs, we can get a patent grant in USA also.
Okay, EU is how much?
EU is costly, like because it is combining all the states, all the 34 contracting states, including UK. So it is at the filing stage, it is around 4,500 euros.
Oh, okay.
Yeah.
And with that, this one included? I mean, later.
Examination fee, including the examination fee and including the third year renewal. Means they are like second year renewal. Like they start taking renewals even at the stage of application. EU, also in some countries, even in Dubai, all the 7 countries of GCC, they also take renewal fee from the stage of application. But in India, for example, and USA and most of the countries, they won't take renewal until the patent is granted. After patent grant, like whatever is due and further, they'll collect yearly renewal. And in USA, like they collect renewal for every 4 years. They collect a renewal immediately after grant, and then after that, like at fourth year from the date of grant, 7th year from the date of grant, and 11th year from the date of grant, and 15th year from the date of grant. So they collect 5 times patent renewals. India collects from third year. So if it is due, I mean, for example, if it is granted in 1 year itself, then they won't ask until the third year, start of third year. From the third year, we need to pay the renewal fee.
All
But
these, all these to be filed in one go. You said Srinivas Garu.
it's up to you, sir. So we have 12 months time directly as a convention application, or through PCT 30 months. Either we have to decide and file all the applications within 12 months from the initial filing date. It can be an Indian application or any application. The first application, like inventor is no bar, applicant is no bar, like nationality is no bar for patenting, sir. Anyone can file.
No, it's a case where I have filed an application for patent and I got the grant in India. Now,
Yes.
other jurisdictions, I have the same business, and the patent that I have obtained in India has relevance for other geographies as well. Then, when to file all those
From
applications?
the date of filing, it is 12 months, sir. Not
Hmm.
not from the date of grant. Date of grant can be 9 months, as we are talking about early examination, or it may take 3 years also. So you should not think of actually filing your foreign applications after grant. So you have to schedule your filings based on your interest from the date of filing.
Thank you
What
very
I'm
much.
telling
Thank you
is
very
like
much.
the first application can be anywhere. Even you can file your first application in USA. There is no need like there is no rule that because you are a national of Indian, because you are an Indian national or your entity is an Indian entity, there is no rule like you have to file your application in India. You can
That's a good point. Thank you.
file in USA also.
No, I missed that. What was the last point? Sorry.
For patenting, there is no cap on number of applicants or age or creed. There is no cap on number of inventors. There is no cap on nationality. There is no cap on, like, for example, As an Indian national, you can file your first application in USA also. That will become your first application or home application. And from that date, like you have to file all your applications within 12 months. If you are unable to file or locate your countries, then you can have an option to file your PCT application and then take some more time. But the ultimate time is 30 months.
I see. Okay. So this end to end now, you had mentioned US is about 4 lakhs, India is about 1 lakh. Europe is how much, you said?
To file the application, it is 4.5 lakhs, sir. 4,500 euros.
End to end is how much?
In the prosecution, if there are no objections, like very critical objections, it may take around 2,500 euros. Means approximately in 7,000 euros, you can get a grant.
It works out to about $8,000, right? Something like that.
You can take equivalent to 1 lakh, sir. 1,001 lakh. 1,000 euros is equivalent to 1 lakh. So 7,000 euros means 7 lakhs.
Okay. Any idea on, I mean, Africa, is it treated as one, or Middle East?
Yeah, ARIPO, there is a group called ARIPO, includes 17 countries. And there is one more group called OAPI. Again, it has 17 countries. So there are two group applications for covering Africa, but not covering, both groups are independent, again, because of different, like Madrid or like GCC or G5. They had a group, like two groups. So we can opt for any of the groups. And some of the countries are independent again. South Africa is not part of any group. And some more countries also not part of any group.
Srinivas Garu, I think the other speaker is also waiting, so we have to.
Yeah, I also have to have a.
Sorry.
Thank you for all joining this session. So I'll rejoin maybe after 20-25 minutes.
Thank you.
Thank you.
Now I invite Mr. Vijay Bhaskar Reddy. So he will be highlighting regarding the IP management and enforcement strategies.
Hello all, good afternoon. So it was a wonderful session from Srinivas.
I think Vijay, we are falling short of time, so you have to cut short and all the.
Yes. So the topic given to me is mainly about the IP enforcement. So IP management and IP enforcement. So till now we have discussed about till the grant of patent or grant of IP. So hope you are able to hear me, right, Swapna?
Yes.
Yeah. So here the next stage is, so because these are IP is like it's not just for any kind of research or anything, but it is like if you treat it legally, it is a commercial asset. So IP is a commercial asset. So if you want to manage it properly, so then we have to look at the commercialization of the IP, which is very, very important. So first thing is in the IP management, creation and identification of IPR, and then protection of IPR through proper registration for the kinds of IP you have. Next thing is commercial exploitation of IPR, and you are manufacturing, you are licensing, and the next thing is enforcement against infringement. So this is very, very important. You have created your IP, you are commercializing your IP. Main thing is like how you are enforcing that IP against the infringement. So that is very, very important, because if you do not enforce your IP, then your IP is at risk, though you are commercializing. If you look at the restaurant names, if you look at the school names, especially in the trademarks, even if you look at the lyrics, even if you look at the books, movies, so if you do not take proper steps against the infringement, then one day it becomes a generic. If you look at Xerox, right? Xerox is the name, actually the name of a company. So it was at the risk. So there was a case at the High Court of for the state of Tamil Nadu. So in the High Court, what happened is like it was a very difficult task for the management of the Xerox to say that it is a trademark of the Xerox INC, because it became a generic, and people who are using other machines, other photocopying machines. So they were also put a Xerox inside or Xerox available. So there were some big players who are using Canon machines and some other cheap machines, but still they have put it as Xerox outside. So Xerox was doing its own business. It was having a trademark. It was commercializing its trademark, but it was weak at enforcement of or the IPR. So somehow, with a great risk, the Xerox management won the case, and it was decided it is not a generic name; it is a trademark which is registered by the Xerox. So it is very important for anyone. If you look at escalator is also a trademark. If you look at kerosene also was a trademark by someone. So over the years, what happened was it was not maintained properly. So it became a generic word. So therefore, you need to, like Google. So Google, like instead of doing internet search, we call them as a Google it. Whether you do it using Google or maybe some other internet. So still we call it as a Google it, and you find the information. That's what teachers tell to the students. They will not say that you do proper internet search, or you can like that one. So therefore it is very important in terms of especially trademarks. So if you do not take proper care, simply it becomes a generic word. So even if you after few years from the word that becomes generic, even if you go to the court of law, then it will be very difficult because you did not take proper action in the proper time. Yes, so this is about IP management, and even in the enforcement part. So there are remedies as well. So there are remedies. Remedies include seeking civil actions and criminal actions. So like in the civil, we talk about injunctions, damages, and destruction of infringing goods. And in the criminal, so we talk about police raids, seizure, and imprisonment and fines. So this is in short about the IP management and IP enforcement, sir. So maybe during the question and answer session, I can explain you more about this part.
And question is, supposing there is a patent
Yes, sir.
and someone creates something which is slightly different,
Yes, sir.
and he tries to say that I am patenting that, or I am this does not exactly match your patent, then
Yes,
is
sir.
it a good practice to file so many patents surrounding the main idea? So that
It
the
is
second,
always, it is, if you, that is a practice followed by big companies. So it is called as a fencing of patents. Like
now
if you have
what is
one
it?
main fencing, how we fence
Fencing
our
of
plot.
patents. Yeah.
Yeah, how we plot our land,
Uh,
agricultural land. Similarly, we call the same word fencing of the main patent.
uh,
So we see that one, okay, even if there is a slight improvement of the main patent application, we'll try to file it, whether irrespective whether it is granted or not. So we'll try to fence it in a proper way. So the main invention and the optional features. Many times optional features, maybe they were not invented at the time of filing patent application, or maybe the inventor felt it's not so important at that point of time. So therefore, what we'll do, so even there are slight improvements over it, so we can file it as a patent of addition and we can fence it. Is it clear? And coming to the infringement part, so mainly what we have to see is the claimed aspects. So if there are so many claims at the time of filing, but there will be objections during the examination. So by the time it comes to grant or after grant, so if you look at, so main thing is the whatever we are claiming at the time of application will be different, because there are objections from the patent office. So ultimately, it is the granted claims so that give the protection. So if the scope is very narrow, if the scope is very less, we cannot take action. So in the court of law, it will be very difficult to say that, yes, I have a patent. So then the court will refer to a team, and then they will look into the claims part. So if you are not able to justify the claim, then it will be very difficult to take action against the infringers.
so mere disclosure does not offer any protection.
No, it will be only a supporting document. What is unclaimed, it will be very difficult. So for this reason only, we have a claim section in the patent application. Disclosure will indicate that you are the creator of that one, but it will not give you exclusive rights.
Hmm.
So in order to get exclusive rights, it is very important to put all the features of the invention in the claims part. So that's the reason why generally review of claims and review of patent application once, twice, thrice also is fine. So then we can ask the attorneys, okay, is that feature, is this is the main feature, is it properly protected? And how are the dependent claims? So are the dependent claims giving enough support to the main claim or not? So these kind of things have to be checked in before filing the complete specification, because many times in the during the time of at the time of filing provisional specification, you will be in a hurry because you want to go to conference or you want to have a discussions with the investors. But before filing the complete specification, it will be very important to look at these things, because once filed it will be very difficult to amend the claims. So generally even though there is a possibility of filing amendment, but it will be very difficult, the patent office may not accept the views. Yes, is it clear?
Which country is it easiest to get patent relatively?
So in the patents as well, so there are two types. One is a utility patent application, and the other we call as a utility models. China has utility models, Germany has a utility models, South Africa has a utility model. So many people nowadays they are going to outside and they are getting some kind of certificates. So what they are getting is a utility model certificate, and they call it as a patent certificate. So almost all the countries like it's not such easy or tiff, but this is one way of getting a patent by filing as a utility model.
So that is treated as a patent?
Almost yes, almost yes. So but the protection it offers, the term of that patent is less. So 7 to 10 years. Most of the researchers, most of the academic people, like they are going to different countries, like including South Africa, Germany, and other countries. So where they are filing as a utility patent application and they are getting the certificate as well. Like if main thing is instead of looking at which is easy, so what we have to see is what are the distinctive features in my invention that are different from the prior art. So if you have identified those distinctive features, and if proper support is made in the description part, that means enablement of invention, sufficiency of disclosure, then anywhere you will get it. But other thing is, so why you want to file a patent application in that particular country? So because there is a cost involved, right, at every step. So if you think that there is no market, if let's say you have invented a nice mobile computer, hardware, chair, whatever the fan it is, and it has no use in particular countries, so then no need to file. Let's say you have invented something for desert countries, so which may not have use at all in polar countries. So then there is no use at all. Maybe if it is like if you are finding some solution for underdeveloped countries, maybe for mobility purpose or any other purpose, which may not have any use in developed countries. So it is very important to see whether, because these are, I told you in the beginning itself, these are the commercial assets, and there is a fee involved at every stage. So you have to think, is it a right way to file in that particular country or not? Yes, sir. So already we are getting late. So if you have any questions, so you can ask. Yes, Swapna ma'am. So over to you, I think.
Yeah, thank you, Vijay,
Thank
for
you.
the session on the IP management and enforcement. So if they have any queries, they will write to you. So you can put your contact details in the chat box so that they
Yes. Yeah, or you can write to Swapna ma'am as well. So no problem.
yeah.
Yeah. So
Okay, so since we are running short of time, we will be quickly going through the schemes that support the innovation and IPR.
yes, over to you, Swapna.
Hmm. So, as the speakers were discussing about the IP protection and the facilitation services through IPFC, so we have various schemes under Ministry of MSME for promoting IPR and innovation. So, before discussing on that, everyone, you should know about the classification of the MSME, which was updated, and now the criteria is based on the investment and turnover. So to avail any of the scheme, so this Udyam certificate is important. So many of the MSMEs and startups are not aware about this. Though we have around 63 million MSMEs, we have only 7 crores, I think, which have been registered under Udyam. And there is a lot of campaigns going on with the support of ministry to register all the MSMEs under this. So, as per the classification, a micro enterprise is defined as if the investment is 1 crore to 2.5 crore and the turnover limit is 5 crores to 10 crore. And small enterprise, if the investment is 10 crores to 25 crores and the turnover limit is 50 crores to 100 crores. And medium enterprise, in now the investment is from 50 crores. Earlier it was 50 crores. Now they have increased to 125 crores, and the turnover limit is from 250 crores to 500 crores. So now you see many of the enterprises are coming under the small, medium enterprises. So now the ministry has a very bigger role to play, because many of the enterprises are covering under this classification. And for that, there is an Udyam registration, which is a paperless and free registration, which is based on the self declaration. So this is a site where any enterprise can go through the site, and they can submit the documents. Basic requirements is they should have the other proof, and also GST number, okay, and their enterprise location details, bank details, and everything. It is based on the self declaration, and they will be getting the certificate generated online. And in that, it will be clearly mentioned whether it is a micro enterprise or a small enterprise or the medium enterprise. And this certificate will be very much helpful for the enterprise if they want to avail any of the schemes of Ministry of MSME. Not only Ministry of MSME, but any scheme under the Government of India, they can get the benefits of the MSME by showing this Udyam registration. Okay.
So,
And
question is,
coming, yeah,
question is, the startups, where do they fall?
startup.
Huh.
Yeah,
Where do
and
they
for
fall?
startups also, there is a startup recognition certificate provided by DPIIT, where if, for them, they should have some innovative product. But for Udyam registration, it's not such. Any enterprise can, any startup company can also register under this.
Okay, so services would not, I
Yeah,
mean, startup.
both the services and the manufacturing units can register under this.
Okay, in startups also, there can be products or services, right?
Yes, yes. Okay. And the most important scheme under the Ministry of MSME is MSME Innovative Scheme. Earlier, there was a separate schemes for the incubation, design, and IPR, but now they have clubbed and made it as one scheme, MSME Innovative Scheme, which supports the design registrations and also IPR and the incubation component. So under incubation component, they have empaneled host institutes like NIMSME is also one of the host institute, and there are many academic institutions and also national institutions and IITs which have empaneled under this particular scheme. And any individual or an MSME, any one who is having an innovative idea can submit their idea through a MSME hackathon. Okay, MSME hackathon, which will be notified by the Ministry of MSME every 6 months, and they specify certain themes. Okay, like green technologies, EV related. So any themes, whatever the themes they specify, if anyone is having an innovative idea, they can submit their idea and they can get the support of 15 lakh rupees if their idea got selected. Okay, and they can get the mentoring and handholding support through the host institute. So there are many host institutes which are already empaneled. You can select any of the institute which is near to you, or which you feel that they have an expertise in that particular domain. Okay, so this is a incubation component under this particular scheme. And this is a process flow. Once you have an idea, and see, every 6 months Ministry of MSME gives a notification, and currently MSME idea hackathon 5.0 screening is going on. So soon there will be one more hackathon after a few months. So this will be given on NIMSME website and also in the ministry website. Anybody, any individual or at a startup company or any enterprise, they can submit their idea and they can get the support of maximum 15 lakh rupees under this particular uh, thing. And for the host institutions also, since many are from the academia also, if your institute is empaneled as a host institute, and they can also get a financial assistance for the plant and machinery to support the handholding support for the that particular idea. So up to 1 crore rupees support may be given to the host institution, and 15 lakh rupees for the selected idea. Okay, so this is a website where you can go and get the details, MSME innovative scheme. Okay, so initial level the screening will be done at the host institution, and there is certain criteria which is already predefined, and they will go through, they will do the assessment, and then they will forward that to the ministry, where they will give the final approval and provide the financial assistance of 15 lakh rupees. Okay, and there is one more component under this particular scheme, that is design. And if any MSMEs want to develop some new designs, okay, for that particular product, and they want to take the support of an institution which are empaneled like NITs, NID, where they can get the where they can get the expertise to do the design intervention. They can avail that services, and whatever the services they have, the professional charges will be funded through this particular component. So for they can get up to 40 lakh rupees, and for the design project. Even the student design projects are also funded through this particular scheme. 2.5 lakh rupees support will be given for the student projects. Okay, so any MSMEs can avail through this particular link.
So even IT companies are eligible, is it, or not?
IT companies?
Are they eligible for all of this? The previous one and this one?
Yeah, provided they should have some Udyam registration. Okay, and they should take the expertise of the empaneled institutions. Okay.
Okay.
And the third component is IPR. And under this particular scheme, they provide legal support, filing support through the IPFC centers like NIMSME. We have an IP facilitation center which is funded by the ministry. So we got a support of 1 crore rupees for doing the services for MSMEs. So they have to bear the government fee, but the professional charges will be waived off under this particular fund. So the main support that is provided and is pre-filing. We also support in documentation and filing, and also the post grant if they want to file a renewal for their registered IP, that also we support. Okay, and we will be also giving the advisory support and also technology transfer guidance. Okay, so all this will be provided by the facilitation center. And even if any research institute or any company, if they want to see what is the state of art in that particular area. So earlier Srinivas sir, he mentioned about this particular thing. If they want to know the updated status of the technologies in that particular area, okay, so they can go for the prior art searches. And if they have the invention, then they want to see whether their invention is patentable or not, they can go for novelty search. And suppose if it already have somebody, some companies having the IP on a particular invention, and you want to acquire that particular invention, or you want to take the license, and you want to see the validity of that particular patent, so we also do that. And we also provide advisory services for MSMEs. And in the protection stage, we do all the type of documentation, drafting the patent application and filing. Okay, not only patent, but also we do for trademark, GI, copyrights, and also design registration. And post protection stage, we also help in IP maintenance. We also give advisory on the enforcement of IP. See, recently I want to highlight one case. We have filed a trademark for one of the micro enterprise. Her actually her brand is an Arya Naturals. Where we have filed the trademark, and it was granted. Okay, so she told that she has come across a similar brand, which they have been advertising that particular brand on the social media. Okay, so she told that we have already got a granted a trademark, and how there is some company which is infringing their brand name. So we she seeked our IPFC services, and our attorney has sent a legal notice to that concerned company. So this type of support also we give. And we also help in networking. Okay, so networking with some potential buyers. Okay, we do technology scouting. And as earlier speaker also mentioned, that IP audit is very much important for SMEs. Though small companies, they don't focus on that, but identifying the right technology which has to be protected and what has to be maintained, this IP audit has to be made mandatory. And even I was also member of a joint working group for revision of this particular scheme. So in that, we also recommended that every company, before providing the financial support under any of the scheme, this audit has to be done. And based on that, the funding support to be given to the MSME, so that the type of the level at which they are, and the readiness, because we are focusing only on the IP registration, but we are not actually helping them in the commercial angle. So whatever the ideas they have, and if there is any commercial potential for that particular inventions or the ideas, so we can suggest the ministry to support such ideas, so that they can those ideas will be um, developed, and it reach to the market. Okay, so that is also one of the recommendations that we have made. See, we have been we are doing a lot of filings, but when you see how many filings, how many IPs are converted into come sorry how many IPs are converted into the product, and that has been reached to the market, we see only few technologies. And even you see research institutions, they do lot of IP, but we see only few products coming out of that. Okay, so there is more focus is on the commercialization of the technologies which are being protected now. That's how there are technology facilitation centers that we established in the research institutions. So ministry is supporting for that, and IPFC is also providing the guidance on these particular aspects. And as I said, the IPFC, we will be getting, I mean, any institution which is working with the MSMEs, they can write a proposal to the ministry to support for setting up the IPFC center. So they will be getting 1 crore fund. And through the IPFC also, there is a reimbursement of the IP expenses that is incurred. Suppose they have hired an attorney outside, and they have taken their services and the patent has been granted. Now the expenses whatever that is incurred, they can get the reimbursement through this particular scheme. So foreign patent, 5 lakh rupees support is reimbursed, and domestic patent 1 lakh rupees support reimbursement, and GI registration 2 lakh rupees, and for design registration 15,000, and for trademark 10,000. And these design and trademark, which is very much helpful for the small entities, because they cannot afford in developing some new products, but with some design modifications, they can get this design registration, and also the expenses that is incurred can be reimbursed through this particular scheme. Okay, and as there are other components also in this particular scheme. There is a lot of awareness program that we are conducting all over India with the support of Ministry of MSME, and we are also doing some specialized training programs for the officials, industry officials, MSME officials, and even for the entrepreneurs also, on various aspects, especially on brand protection, on IP commercialization, on patent filing and drafting procedures. Okay, so like this we are doing. Even we are also conducting training programs for the all IPFCs also, how to the coordinators or the professionals working in this IPFCs. We are also giving the capacity building training programs on various aspects, like patent searches, patent filing and document drafting, and filing procedures. And ministry is also organizing national workshops, state level workshops, regional workshops with the support under this particular scheme. Okay, and there is also component for the foreign travels, international trainings. Okay, and exposure visits also, to learn about the best practices relating to innovation aspects. And I'm happy to inform that as a part of that, I have been also nominated for mm, international training program on IP and commercialization at Copenhagen Business School. So like this, under this particular scheme, there is a provision also where the officers are being trained in the international business schools. And we also have a seed capital support for the MSMEs. So this is operated by SIDBI, and under this financial assistance up to 1 crore rupees. Okay, for the commercialization of ideas, designs, or the patents, and facilitate the pre-investment series funding. So this is also with the approval of the ministry. This particular fund, seed capital support, is also provided, and sanction order So many startups are availing this particular support. And there is recently the ministry has set up the technology transfer facilitation center at various research institutions. One we have at IIT Hyderabad, one we have at CSR IICT. Okay, so this mainly helps in technology transfer and IP commercialization. So they will be providing technical support in facilitating the commercialization or tech transfer agreements. And there is also component called IP assessment, sorry, access fee. If any MSMEs want to access any of the technologies which is IP protected, okay, so they can get the support under this particular scheme. And even the foreign filings, okay, international IP registrations, if any MSMEs want to go, they can get the support under this particular scheme. So the main responsibility, role and responsibilities of TTFCs is they conduct MSME Tech Connect event. So in February, we have this MSME Tech Connect event at IIT Hyderabad, and all over technology facilitation centers, they are doing this MSME Tech Connect event, where they are inviting the MSMEs and also industries who can take up that technologies. And even the research institutions are also invited, so that the collaboration can happen. So this events have been and also if the technology, as Srinivas sir already mentioned about the TRS levels. So if any enterprise wanted to develop their technologies and enhance their TRL level, so this type of support is also given by the TTFCs. And if they have any technology and they want to evaluate their technology, so that kind of support also provided this. And capacity building workshops are also conducted, and they also act as a mediator in case of any dispute resolutions, so they provide this assistance also. And regarding the reimbursement of IP access or IP acquisition fees, this is a support actually for Indian patent 10 lakh rupees, foreign patent 15 lakh rupees, copyright or a trademark 2 lakhs, and for any biomaterial or tangible research property 10 lakh rupees, data sets 3.5 lakhs, know-how or trade secrets 10 lakhs. So in many MSMEs, they have this trade secrets and a know-how, which is having some, which is very crucial. So they can get the support under this particular component. And for the foreign trademarks also, they can get the support reimbursement of 1.5 lakh rupees, and for foreign design registration 1.5 lakh support is given. Okay, so there are many schemes and the support that is being provided for MSMEs, but due to lack of awareness, not much MSMEs are availing these particular facilities. But this is a platform where we are giving this information, and you if you have anyone who can take this help, so you can send their contact and tell them to avail this particular services. And we also have Startup India Seed Fund scheme, and it is mainly to support the early stage startups. So there is a funding support of 20 lakhs for the prototype development and 50 lakhs for the product trials, market entry, and commercialization. So this seed fund, Startup India government and NRDC is also one of the institution which is supporting this particular implementing this particular scheme. And we also have BDAC, where they are giving biotechnology ignition grant. It is called BIG. So they give the grant up to 50 lakh rupees for the biotechnology related product projects. Okay. So this proposals they generally call twice in a year, and it will be open for 45 days. So any applicant means they can be a startup, innovators, or any researchers, they can get the grant through this particular scheme. And one more important thing is World Intellectual Property Organization. It's an international organization which is situated in Geneva, which mainly promotes the IP rights in different countries. So this organization had a great initiative, and they have set up technology and innovation support centers all over the world. And we have one at ICRISAT, and these centers mainly facilitate the access to the IP knowledge, patent information, and help the innovator to know the landscape of that particular technology in that area. So they do they do prior art search reports, they do novelty assessment reports, and they have the databases where if any innovator want to know whether their invention is patentable or not, or they want to know what are the latest developments that has happened in that particular area, they can take the services of this technology and innovation support centers, and they can get the reports. Okay, so they give the guidance on the IP commercialization and licensing, and they also support in patent drafting and filing also. So any MSME, startup, researchers, students, and individual innovators can take the services of this TIS centers, technology and innovation support centers. So this many are not aware about this, but this is also one of the facility which you can get the services free of cost. So they provide patent, trademark, and design search assistance also. If anybody having any brand name and they want to know whether their brand can be trademark or not, if they are already having that, and they want to see how they can commercialize, or how they want to expand their business, how they can especially in making some legal agreements also, where IPFC also supports. But also this technology and innovation support mainly deals with the technologies that are being developed. So more focus on the patent and design registrations. And there is also one more scheme called IDEX scheme, Innovations for Defense Excellence. So this is an initiative by Ministry of Defense, Government of India. So any startups and MSMEs and academia who want to develop some defense technologies, they can get the support under this particular scheme. And they provide support for prototype development, and they can also access the defense testing infrastructure, so mainly relating to Army, Navy, and Air Force. So this is a scheme where they can get the support. Okay, so they also give a notification inviting the proposals from the individuals, MSMEs, and academia. Every year they invite, and they support for the defense technologies. Okay, and these are the some of the schemes where startups and MSMEs can get the support for the IP and innovations. Since I've already mentioned as I already mentioned that IP facilitation providing supports for all the pre and post registration we provide, but MSMEs mainly focus only on the trademarks and the design part, but there are some patents also we are filing for the MSMEs. And I request all of you to disseminate this information. And if you have any need for the IP services, you can approach IP facilitation centers, and we are providing free of cost services. Only the government fee has to be borne by the MSME, but they can get the reimbursement after the grant of the patent or the trademark, whatever you are seeking the service. So that reimbursement will be given only after the grant. For even for the government fee also, whatever that you have spent, you can get that amount. Okay, so this is a benefit through this particular scheme. And as many are focusing only on the filing, but we have to focus on getting whatever the product, innovative product that you are thinking. So it has to come to the market. So there are a lot of stages. So networking and collaboration is important aspect. So the ministry is doing a lot of events, okay, inviting the industries, inviting the researchers, innovators. So this collaboration, through collaboration only they can get the expertise, or they can link up and develop their product. So MSMEs have limited resources. They can use such platforms to identify the right resources for developing their products. Okay, so with this, I thank you, each one of you, for participating in this webinar. And if you have any questions, I'll take up, or you can put up, you can mail us, and I will be giving my mail ID and a WhatsApp number, so that if you have any queries, you can send it to us. Anyone, any questions? Any questions? Okay, thank you, one and all. And thanks for showing your interest. And we'll be sending you the certificates through mail. Okay, thank you.